Good morning, everybody. All right, we are back on. Defendants are present, represented by counsel. When we broke last night, we were addressing motions before the court. Probably the most efficient way to go about this is the stated indicated. Want a little bit of time to take a look at the demur on count 7. This is the state of any additional argument after reviewing the demur that had been filed on behalf of Mr. Bryan.
No additional argument. We stand on what we had originally filed and on the court's order on the demur to count 7, which is, it tracks the language of the statute and informs the defendants of what they are to defend against, and therefore it is sufficient, and there's no reason to grant the demur to the indictment on count 7.
All right. Go ahead and address that. Then let's get through any additional motions, and I'll start addressing the motions as we go. I probably should have gone around and asked the question that normally leads to some time before the court. Before we get started, anything from the state? From Travis McMichael?
No,
From Greg McMichael?
No, we're ready for our motion.
And from Mr. Bryan?
Yeah, you got it.
Motions then. I'll just go around, same.
Mr. Hogue is going to speak for both Greg and Travis McMichael.
Your Honor, at this time, on behalf of Greg McMichael, and I will speak for Travis McMichael with permission of co-defendants counsel, and invite them to add anything you may wish to add that does apply specifically to Travis that I may not mention, but I'm going to try to cover both in this motion for directed verdict of acquittal. And I'll start with the statute that applies to such a motion and then go through the counts in the indictment that I think we have some argument to make regarding it. First, the statute. It's OCGA 1791A, which says, where there is no conflict in the evidence and the evidence introduced with all reasonable deductions and inferences therefrom shall demand a verdict of acquittal or not guilty as to the entire offense or to some particular count of or offense, the court may direct the verdict of acquittal to which the defendant is entitled under the evidence and may allow the trial to proceed only as to the counts or offenses remaining, if any. So I start with count 1, and let me get my indictment up here, which is malice murder. And to make this argument for acquittal on malice murder, allow me to review initially what the elements of that offense are, and then talk about the evidence in the case. The statute, of course, is 1651 A and B, and 1651 A says a person commits the offense of murder when he unlawfully and with malice aforethought, either express or implied, causes the death of another human being. So starting with just subsection A, malice, of course, in Georgia law means a specific intent crime as opposed to a general intent crime. And in a specific intent crime, the subjective desire of the defendant is to bring about the exact illegal consequence that his action is intended to produce. So in a malice murder count, that means that that malice means the defendant has the specific intent to commit an act that the cause of which is the death of another person, and that result was the desired result. It was not an unintended consequence, as we'll see is the case with felony murder. So malice, that sort of specific intent, can be shown in two ways by proof, and that's subparagraph B in 1651. And that paragraph indicates two types of proof of this malice, this specific intent. Of course, I always mention that as the definition of malice because it's certainly confusing to jurors, but that's a different issue for later when we talk about charges. But it means no intent, no ill will or hatred, of course, but it's just a specific intent. Two types. Express malice is that deliberate intention unlawfully to take the life of another human being, which is manifested by external circumstances capable of proof. Now, case law indicates that would be things like verbal threats, lying in wait, the kind of circumstances or actions for which the state can produce evidence that says this person had express malice. It's out there in the world for us to see it. We can hear it. We can determine it from the circumstances in which the killing occurred. The other type of malice, much more sticky, is malice shall be implied where no considerable provocation appears and where all the circumstances of the killing show an abandoned and malignant heart. So to further define that type of malice, I need to go to a different place here in my notes to look for a definition of implied malice in our law. What we're looking for is that specific intent to kill where there are no external circumstances capable of proof, but inferences must be made. It's implied. And first of all, you have to find that there's no considerable provocation, which would be, say, voluntary manslaughter, and there's no other justification for it. And then in one of our cases under Georgia law, which is Parker v. State, and I'll get the site here, 270 Georgia 256, a 1988 case. Essentially in Parker, the court tries to define that poetic metaphor we find in the implied malice sentence, which is the abandoned and malignant heart. I find it of interest that there are only 4 states left out of 50 that use that phrase in their definition of murder. Abandoned and malignant heart, having its roots somewhere in the dark recesses of medieval English, but here it is still in Georgia. Idaho, Nevada, and California are the other 3 states that still use that phrase. And so Georgia, in attempting to say what it means, says that it's a reckless disregard for human life. And Justice Hunstein in Parker v. State tries to give some sort of definition for it. It's not a substitute for implied malice. That is, reckless disregard is not a lower mental state or lower standard of proof. It's not equivalent. It's, as she says in this opinion, a special concurring opinion, she says the difference between instructing a jury that a presumption of malice may arise from reckless conduct, and this is for malice murder, and instructing them that reckless conduct and malice are equivalents that can be substituted for one another is not just a matter of mere semantics. A jury is entitled to be instructed how to determine a defendant's state of mind based on the evidence adduced. It is not entitled to be instructed that a lesser mental culpability may be substituted for the required higher mental culpability. And then she goes on to criticize the charge given in that case in Parker. But what it comes down to, and it's even cited later in a U.S. Supreme Court case, actually it was a case earlier than Parker, and also an attempt by Justice Brennan to define it. And the case is Arave, I'm sorry, let me start that over. A-R-A-V-E, Arave v. Creech, C-R-E-E-C-H, 507 U.S. 463, a 1993 case. Justice Brennan wrote this: homicides committed without considerable provocation or under circumstances demonstrating an abandoned and malignant heart, a term of art that refers to unintentional homicide committed with extreme recklessness. And then I just use ellipsis there because he goes on to another matter. But the examples given would be, say, somebody shooting a gun into a crowd of people. You aren't intending to kill any specific person, but you certainly know by that reckless act somebody will die. Or driving a car into a crowd at a protest rally. Somebody's going to die. This could be an abandoned and malignant heart. So, that all aside, now the facts of our case, going back to the standard of 1791A, where directed verdicts premised upon no conflict in the evidence, and all reasonable deductions and inferences therefrom. In this case, the state's case in chief, which we've just now heard for the last week and a half, the express malice does not seem to be there. Speaking about Travis McMichael in particular, he's not saying anything or doing anything that could be provable by external circumstances to be express malice. And as we've all seen in the video, the shooting doesn't occur until he and Ahmaud Arbery are locked up in mortal combat, hand to hand, face to face, and in contact with one another, with a gunshot wound that's fatal, that's close contact or near close contact, 1 to 3 inches away. Now, none of that is in dispute. There's no conflict in the evidence there. Obviously, the issue that we expect will go to the jury is whether that was an act of self-defense or whether it's some felony murder, and there are counts in here that address that. There is a pair of counts that talk about using a shotgun as an aggravated assault which results in the death, and that's felony murder. Those are 2 separate counts in this indictment. It's always interesting too that malice murder added in the same case with felony murder, while not legally inconsistent, and of course George has done away with the concept of legally inconsistent verdicts, is somewhat logically inconsistent. When you ask a jury to consider finding a defendant guilty of malice murder based on proof you think you have, if you're the state, that he specifically intended by his act to cause the death of the person who died, and at the same time argue to them, but hey, also consider that he used a shotgun in an aggravated assault without malice, as the felony murder statute says, and the unintended consequence of that aggravated assault was the death of another person, therefore it's bootstrapped up into felony murder. So that is the argument against count 1 under 1791A as a count that should not be presented to the jury because there is no conflict in the evidence. All of the reasonable deductions and inferences from the evidence do not support a finding by a rational trier of fact that express or implied malice have been exhibited here in the act of shooting Ahmaud Arbery. Now, Your Honor, I can go on to each of the other challenges in turn or stop.
Let's go ahead and get the entire
Okay.
motion out.
The second challenge is to the combination of counts 5 and 9. And let me get my indictment back up. Count 5 charges felony murder premised upon count 9. And of course, we know that felony murder, and I'll get the definition of that, is in 1651C. A person commits the offense of murder when in the commission of a felony, he or she causes the death of another human being irrespective of malice. So we can forget all of what I just said about malice because it doesn't apply here. The state would have to prove the underlying felony and then show a causal connection, proximate cause between that underlying felony and the unintended death without malice. And in this case, count 9 is the criminal attempt to commit a felony, namely false imprisonment, on, let's see if it says it in here, Burford Drive. Count 9, then, as we know, is the allegation that on Burford Drive, the beginning of the encounter with Ahmaud Arbery, that Travis and Greg McMichael, along with Roddy Bryan, but I'll leave his lawyer to argue his case here, but that Travis and Greg McMichael, using their Ford F-150, attempted to commit the crime of false imprisonment. And then they combined that with count 5 to say that that's a felony murder premised upon that attempted felony on Burford Drive. Well, the causal link between the attempt to falsely imprison someone 3 or 4 minutes before shooting them with a shotgun is just too tenuous to support, under the proximate cause analysis, a felony murder charge in count 5. I'm not saying that count 9 can't stand and be presented to the jury, but when you combine it with count 5 as the underlying felony for felony murder, what we're facing then is a complete lack of a causal link. I mean, you can add several links to get to Holmes Road where the shooting occurs, but there is nothing about the attempt to false imprison Ahmaud Arbery on Burford Drive with a pickup truck, particularly Travis McMichael's Ford F-150, and his ultimate death on Holmes Road. And if you try to do it by party to the crime, 16220, and connect Travis and Greg McMichael to William Roddy Bryan, as that count does, because it also names him in count 9, names his truck, his Chevy Silverado, in count 9, and then connects them both back to count 5 for felony murder. But 16220, party to the crime statute, I'll read, it's not long. Every person concerned in the commission of a crime is a party thereto and may be charged with and convicted of commission of the crime. B, a person is concerned in the commission of the crime only if he, 1, directly commits the crime. And here we're talking about directly commits the crime of criminal attempt to falsely imprison Ahmaud Arbery on Burford Drive. And he didn't, that is, Travis and Greg McMichael, didn't directly commit that crime with a Chevy Silverado. And then 2, intentionally causes some other person to commit the crime. That doesn't apply here. No one's causing anyone else to commit any crimes. 3, intentionally aids or abets in the commission of the crime. That is proof that Travis and Greg McMichael are intentionally aiding or abetting Roddy Bryan in the commission of the crime of attempting to false imprison Ahmaud Arbery on Burford Drive. And then finally, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. So as the evidence was produced here in this case, Roddy Bryan saw the white truck and saw Ahmaud Arbery, made some driveway assumptions according to Ms. Dunikoski, and then went and got in his truck to do what he did. But as we heard, he hollered something that the McMichaels did not hear. The evidence from the state was uncontroverted that whatever he said, there was no indication, no evidence whatsoever that the McMichaels heard it. There was no phone communication of any kind between either McMichael's phones or Roddy Bryan's phones. In short, there was no coordination, there was no participation, no planning, no intentionally aiding and abetting, or intentionally advising, encouraging, and so forth between the two McMichaels and Roddy Bryan on Burford Drive, where count 9 concerns my argument here. So the criminal attempt to commit false imprisonment, if that arguably occurred by the McMichaels with their F-150 on Burford Drive, fails to support count 5's felony murder because of the tenuous causal link, approximate causal chain that's just not going to reach. And secondly, if it's a party to the crime theory, there's no evidence at all that there was any participation, intentional, and that's the key word in the party statute, between the McMichaels and Roddy Bryan on Burford Drive. So that's my directed verdict argument to count 5, and I make it in connection with count 9. And yet I am conceding that count 9 could survive a directed verdict and be presented to a jury. There is a conflict in the evidence there about what the McMichaels were doing on Burford. Obviously, we're saying that excuse me, that they're attempting to make a citizen's arrest. The state says they're attempting to do a false imprisonment. That's a legitimate jury issue. But connecting it to count 5 felony murder, that should be directed in favor of the defendants as an acquittal. All right, my third attack here under the motion for directed verdict of acquittal will be the combination of counts 3 and 7. Again, count 3 is a felony murder count, and it refers to the allegation in count 7. And when you go to count 7, the argument there is that the defendants committed an aggravated assault with a Ford F-150 and a Chevy Silverado, which they allege are objects, devices, and instruments which, when used offensively against a person, are likely to result in serious bodily injury, contrary to our laws. But then they connect it to murder in count 3. Again, however the trucks were used in this case by the McMichaels, the trucks were used, yes, to attempt to detain, to block in, to trap Ahmaud Arbery. But again, the argument here will be for the purpose of citizen's arrest, not for the purpose of falsely imprisoning him or assaulting him with a truck. But more than that, that would be a legitimate jury issue in count 7. But in count 3, neither truck was the causal link in the death of Ahmaud Arbery. It was the means by which to get to the place where the death ultimately occurred, of course. It was the conveyance in which the defendants rode. But the truck itself did nothing to cause serious bodily injury or death, at least the Ford F-150. And this is not alleging in count 7 that Ahmaud Arbery received some injury when he encountered Roddy Bryan's truck on Burford Drive. That's not alleged in this indictment anywhere, even though there's some evidence of contact between him and that truck on Burford Drive. This count is actually not saying anything about that, but connecting it back to count 3, felony murder. So it's the same problem as we just had in counts 5 and 9. It's a failure of a causal link, no proximate cause to show that the truck is connected to the murder in a causative way, and the same with party to the crime. The other thing this combination of counts does, it doesn't say whether this aggravated assault with a truck is occurring on Burford Road or Holmes Drive. We're left to guess which it is. It simply does not specify. Now that's a demur type issue, and that may have been addressed earlier, but here for directed verdict, if the allegation is that the felony murder occurred on Holmes by use of the truck on Holmes, well, the undisputed evidence in the case is while the truck got driven to Holmes Drive, when we see the video, it's undisputed that the truck is parked, the driver is out of it, the truck is not moving, and it bears no connection at all except as a device around which the defendant stood, one Greg McMichael in the back of the truck, Travis out of the truck, and Ahmaud Arbery going around the truck. So the truck is not a causal element in the death of Ahmaud Arbery, and therefore count 3 should be directed as a verdict of acquittal for the defendants. Count 4 and 8 are connected. 4 is felony murder, referring to the allegations in count 8. Count 8 is the false imprisonment allegation, this time on Holmes Drive. And Holmes Drive, of course, is the final place where the events transpired and the tragedy occurred. But this count 8 alleges that on Holmes Drive, using the 2 pickup trucks, the 3 defendants in concert with one another as parties to the crime, falsely imprisoned Ahmaud Arbery, and then the shooting occurs and they make the causal link back to count 4 for the felony murder charge. But again, the evidence in the case was that there was no place on Holmes Drive where the truck was used to block in Ahmaud Arbery. Where the truck is finally parked, as Agent Dial testified yesterday, I believe, under cross-examination with Kevin Goff, he conceded that there were escape routes. There were places Ahmaud Arbery could have chosen to run through yards, across a yard and onto Satilla Drive if he had chosen to. So how one can be falsely imprisoned when the case agent is testifying under oath that he could have kept on running. The truck itself did not impede his decision to turn right and run across this yard onto Satilla Drive and continue down Satilla Drive until he left the neighborhood, or until he encountered the police, which we also have heard with undisputed evidence was on Satilla Drive when the shooting occurred. So he would have run into a police car at the very least, and then possibly Matt Albenzi if that police car was not where the undisputed evidence says it was. So again, count 4 felony murder should fail because it's based on count 8, which count 8, it's fair enough to send to the jury. It's a disputed allegation, but count 4 can't be supported by it. Finally, counts 2 and 6 are connected, and our motion applies to them in this way. Count 2 is a felony murder, this time premised upon count 6, and count 6 is the allegation of aggravated assault with the use of a shotgun, a firearm, a deadly weapon, to wit, a 12-gauge shotgun. This one's a little stickier in this regard because the evidence has come out that Travis McMichael pointed his shotgun at Ahmaud Arbery on 2 separate occasions. There's been evidence presented by the state that as Ahmaud Arbery is running towards the back of the pickup truck, on the driver's side of the truck, Travis McMichael raises his shotgun, and then he lowers it and moves to the left front quarter of the truck as Ahmaud Arbery makes a couple of weaving maneuvers and then comes around the right side of the truck, and then the gun is raised again and this time discharged, and those shots are what were fatal to Ahmaud Arbery. The count does not specify here in count 6 which of those 2 gun raisings is the aggravated assault. Certainly the first one, where no discharge occurred, could not therefore have been the cause of death, and it could not support count 2 felony murder since there was no discharge of a deadly shot from the shotgun. And because the count doesn't specify, applying the rule of lenity, this should be read as applying to that, because that by itself could be charged as an aggravated assault. Had the case stopped right there, had Ahmaud Arbery stopped in his tracks, and the state had chosen to say, well, this is no citizen's arrest, this is just a garden variety aggravated assault. You're pointing a shotgun at somebody for no good reason. You didn't discharge it, you didn't kill him, but it still could be charged as an aggravated assault. Well, it certainly couldn't be ever, under those circumstances, the underlying felony for a felony murder if the guy was still alive, if no shot had been fired. So that aggravated assault, though, is still in play. It's been put in evidence. It's not charged in the indictment, or is it? We can't tell from count 6, because count 6 only refers to one act of aggravated assault with a shotgun. And I guess the jury will be left to presume that it's the second pointing that results in the shooting, which results in the death, which results in the felony murder of count 2. Those are my arguments, Your Honor, for a directed verdict on counts 1, 2, 3, 4, and 5.
All right. Thank you, Mr. Hogue. Let's go ahead and address that motion from the state, and then we'll get to Mr. Bryan's motion.
Thank you, Judge. Yes, OCGA 1791 is the statute that governs directed verdicts. And there's also case law out there that, of course, the court is to view all the evidence presented at trial in the light most favorable to a guilty verdict and ask whether any rational trier of fact could have found the defendant guilty beyond a reasonable doubt. So that includes, Judge, not just direct evidence, but circumstantial evidence as well. In this particular case, all the defendants have been charged in this as a party to the crime. And of course, we've got directly committing the crime and then helping, which is intentionally aiding or abetting in the crime. And then we've got intentionally encouraging someone to commit the crimes. So we've got all of that charged together. Looking, of course, at count 1, malice murder, you may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in an instant, and instantly a fatal wound may be inflicted. That, of course, is the current pattern jury charge 2.10.10 on malice murder. In this particular case, there isn't significant provocation. Mr. Arbery ran away from these men for 5 minutes, tried to get away, and was being forced down the street by Mr. Bryan in his dark pickup truck, accelerating towards him. He tries to go around Travis McMichael. Travis McMichael steps out into the street, blocking the street, pointing a shotgun at Mr. Arbery, and Mr. Arbery tries to go around the passenger side of the vehicle. Travis McMichael traps him and tracks him with that shotgun up to the front of the vehicle and basically encounters him right there. He's so close that Mr. Arbery, he passes this. He is so close that when he does this, he's instantly shot. Instantly shot. The video itself speaks for itself. There is that much time, and that shotgun blast goes off, and Mr. Arbery shot point blank. The trajectory was, as you saw from the medical examiner, right here, straight through. That's where their shotgun pellets are. That's where that injury is. So at this point in time, we have met the burden to prove no significant provocation except Mr. Arbery coming around the front. The medical examiner talked about fight or flight. And I understand the defense is going to argue, well, it's the victim's fault. He should have kept running. It's the victim's fault. He shouldn't have been exhausted. It's the victim's fault. He shouldn't have gone to defend himself. It's the victim's fault. He had all kinds of options and alternatives in the face of their 5-minute attack on him, and therefore it's his fault. But that's not what the law is. The law is about the defendants doing a 5-minute attack that eventually resulted in malice murder. How do you see the malice here? Abandoned and malignant heart. You take a shotgun, you point it at somebody, you track them around as they try and run away from you, and when they turn on you, you immediately fire and shoot. The state asks you to deny the directed verdict for malice murder for Travis McMichael and also for Greg McMichael. He is charged as a party to the crime. Greg McMichael had his .357 Magnum on him. He is also yelling at Mr. Arbery. We know that he previously had threatened Mr. Arbery with, "Stop or I'm going to shoot your effing head off." So he'd already told this man, "I'm going to execute you if you don't stop." So at that point in time, we've got Mr. Bryan coming forward. He sees the shotgun. He sees it pointed not only at Mr. Arbery, but it's actually pointed at himself because he's right behind Mr. Arbery. And he doesn't do anything. He doesn't stop. He doesn't slam on the brakes. He doesn't yell, "Oh my God." He doesn't swerve immediately out of the way to get off the road into a ditch to avoid this shotgun. He keeps going. He keeps accelerating. He keeps driving Mr. Arbery toward the man with the shotgun, thus aiding and abetting intentionally Arbery having to run towards a man with a shotgun. Mr. Arbery could not turn around. Mr. Arbery could not run away back because Mr. Bryan is accelerating toward him with his black pickup truck. Therefore, he is also a party to the crime of malice murder because it shows an abandoned and malignant heart on Travis McMichael's part and aiding and abetting in that by both the defendant, Greg McMichael, and Mr. William Roddy Bryan. With regard to felony murder specifically, as the court is aware, felony murder must have directly caused the death or played a substantial and necessary part in causing the death. This, of course, is from our new jury charges 2.10.20 on felony murder. And in this case, all 4 of the underlying felonies played a substantial and necessary part in causing the death, because without those 4 felonies, Mr. Arbery wouldn't be dead. So we've got our old-fashioned but for, and that's what we're talking about here. Played a substantial and necessary part in causing the death. But for these actions, Mr. Arbery would still be alive. So when we look at, specifically, I'll take them in the order Mr. Hogue went, we're talking about count 5 felony murder and count 9, which is criminal attempt to commit false imprisonment on Burford. The indictment reads, in violation of the personal liberty of Ahmaud Arbery, did unlawfully chase Ahmaud Arbery through the public roadways of Satilla Shores neighborhood in pickup trucks, did attempt to confine and detain Ahmaud Arbery without legal authority on Burford using a Ford F-150 and a Chevy Silverado. So they attempted to confine him, but he managed to get away. They basically both used the pickup trucks. So we've got Mr. Bryan, principal, actively attempting to detain Mr. Arbery. We've got Travis McMichael in his pickup truck. Circumstantial evidence that he is actively attempting to detain Mr. Arbery, because why? Mr. Arbery turns around from the white pickup truck and runs back the other way. And this is after Greg McMichael is in the truck yelling, cut him off, cut him off, cut him off. So at this point, we've got all 3 men acting in concert to attempt to confine him there. Well, how do they do that? They go ahead and do that by aggravated assault with their pickup trucks, by placing him in reasonable apprehension of receiving serious bodily injury. Well, what does that mean? It means their actions, what were they doing? They're using these pickup trucks with the aggravated assault to confine and detain him. So the state has proven that they use these pickup trucks in a manner that would reasonably put someone in fear and apprehension of receiving bodily injury. What does that mean? They scared him. They scared him with the aggravated assaults. And that was part of the false imprisonment. We're going to scare you into stopping by using these pickup trucks to cut you off and run you into a ditch. They were doing it in concert with each other. I want to be real clear. The defense is attempting to conflate conspiracy, which is we pre-planned this thing, or conspiracy, which is wink and a nod. No, we're talking party to a crime, okay? Conspiracy is a completely different charge. We are going to ask for it, but in this case, this is a party to a crime, which is intentionally doing these things to aid and abet. Mr. Bryan's in his driveway. He intentionally gets in his pickup truck to aid and abet the McMichaels, who he sees are actively trying to detain Mr. Arbery in violation of his personal liberty, falsely imprison him. He's actually in the top of his driveway looking down. The white pickup truck, he can see it. Mr. Arbery's running back toward him. They can see that Mr. Bryan is now pulled out. They make a decision based on this to go around homes, but for their decisions on Burford, but for their attempt to falsely imprison Mr. Arbery would not be dead. The false imprisonment on Burford substantially contributed to his death because it's what made him stop running. They didn't allow him to run up Burford and on to Zellwood, which would have then led right out of the neighborhood. Because if he'd gone up Burford, gone over Zellwood, he'd eventually gotten to Satilla Drive and could have gotten away and he wouldn't be dead. So this substantially contributed. But for these actions on Burford, none of the rest of it would have happened. So what did happen? Well, he then has to run back. Mr. Bryan, of course, once again cuts him off. He then immediately turns up homes to get away from Mr. Bryan in his pickup truck, which has now cut him off from his route going out Satilla Drive. But for those aggravated assaults which were used to falsely imprison him there on Burford, he would not have been going up homes, which then led him to encounter the white pickup truck coming down homes. We have him trapped like a rat. He ends up with no place to go, and he ends up exhausted, fight or flight, turns around the corner, and is shot. So all of this led up immediately to the death. And therefore, it's a question for the jury. And in this case, the standard, as the court knows, is we view all of the evidence presented at trial in the light most favorable to the verdicts and ask whether any rational trier of fact could have found that the defendant was guilty beyond a reasonable doubt. That's for the jury to decide. They're going to go ahead and look at this, and but for those actions on Burford, would he have ever been trapped like a rat between two pickup trucks on Holmes Drive? No, he wouldn't have been. So it materially and substantially contributed to his death by getting us to that point. And this is all one continuous event. This is 5 minutes of this going on. So it's not these separate little vignettes. This is continuous. They're going around. Mr. Bryan's driving him this way. They're going this way to go ahead and capture him and trap him on Holmes. And that was their intention, all because they wanted to talk to him. So we've got that. We ask that you deny the motion for directed verdict on counts 5 and counts 9. Then we've got I believe Mr. Hogue then did 3 and 7, which is our aggravated assault with the pickup trucks. Count 7, did make an assault upon the person of Ahmaud Arbery with a Ford F-150 pickup truck and a Chevy Silverado pickup truck. Objects, devices, and instruments, when used offensively against a person, are likely to result in serious bodily injury. 2.20.21, aggravated assault with a deadly or offensive weapon. Assault another person with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. And then, of course, an offensive weapon is any object that is likely or actually does cause death or serious bodily injury if used against someone. It's not in dispute that a 5,000-pound lethal weapon like a pickup truck can cause serious bodily injury to someone. The question is, were their acts, what they did, such that it would put a reasonable person in reasonable apprehension? In other words, did what they do cause fear? Yes. Now, we don't have Mr. Arbery to go ahead and take the stand and go, yes, I was afraid. He's dead. But the jury's allowed to go ahead and look at this and go, okay, let's look at their acts. Did they commit an act that placed Mr. Arbery in reasonable apprehension or fear of immediately receiving a violent injury? Yes, both direct and circumstantially, they did, with aggravated assault with these pickup trucks. So once again now, felony murder, we're back to our but-for situation. So but for them attempting to strike him, cut him off, run him into a ditch, impede him, run up next to him. I mean, Mr. Arbery's just running down the road, and they pull up with a pickup truck right next to him and start yelling at him. Stop, stop, we want to talk to you. So at that point, just that alone, is that an action that would put somebody in fear? I mean, total strangers have pulled up next to you. You don't have a car, you're running. That's a question for the jury. Now, the aggravated assault with the pickup trucks, the state feels not a problem, proven that beyond a reasonable doubt. Did it play a substantial and necessary part in causing his death? Yes. Now, as Mr. Hogue pointed out, at the time of his death, the white pickup truck, which had already been used offensively against him, trying to falsely imprison him on Burford, and then once again coming down Holmes Drive, goes ahead and passes Mr. Arbery. We know this, okay? Because what do we have? We've got Mr. Bryan on the video. Mr. Arbery suddenly turns around. Now, whether you can see the white pickup truck or not, he suddenly turns around and runs back down. Mr. Bryan goes up, Mr. Bryan turns around, he comes back up, and the video's there, and what do we have? That truck is parked at the end of the road. Based on their statements, Agent Dial has testified they went up Zellwood and came down Holmes. That means they passed Mr. Arbery, once again with that white pickup truck. He is pinned between the two of them, the black pickup truck and the white pickup truck, and then the white pickup truck passes him when he turns around and then parks in front of him. That is the aggravated assault. But for them using those pickup trucks in that manner, he would not be dead. Because he's trying to run up Holmes, and the white pickup truck's coming. He runs back down. Now Mr. Bryan's at the top of Holmes, and the white pickup truck's at the bottom of Holmes. He is pinned. Greg McMichael said he was trapped like a rat, and he knew it. That was what Greg McMichael said. So when he's trapped like a rat between these two pickup trucks, did that substantially, materially, did that play a substantial and necessary part in causing the death? It was absolutely necessary, because they had him between these two pickup trucks. They'd caused him fear, actions put him in reasonable apprehension of receiving serious bodily injury with the pickup trucks. And at this point in time, as a party to the crime, they've stopped their pickup truck. But Mr. Bryan hasn't stopped his pickup truck. Not at all. He is coming up behind Mr. Arbery. He is revving that engine. You can hear it on the video. And as a party to the crime, they can see that pickup truck coming. Seeing that pickup truck coming didn't stop Travis McMichael from pulling up that shotgun and pointing it at Mr. Arbery. And then he tracks him around and then shoots Mr. Arbery. The fact that Mr. Bryan and the McMichaels, as a party to the crime of the use of that pickup truck at that moment, it becomes felony murder for the aggravated assault with the pickup truck. The state will argue, of course, that the use of the pickup truck the entire time, but for that, he wouldn't have been where he was. But for all the actions that the McMichaels took in their white pickup truck, Mr. Arbery would not have been where he was and would not have been trying to escape this particular attack and assault. So we ask that you deny the directed verdict on counts 3 and count 7. Then we have, of course, count 4 and 8. This was the fourth one that Mr. Hogue mentioned. I'm going to pause for some water, Judge. Count 4 of the count 8 of the indictment. In violation of the personal liberty of Ahmaud Arbery, did unlawfully confine and detain Ahmaud Arbery without legal authority, to wit. Said accused did chase Ahmaud Arbery with a Ford F-150 pickup truck and a Chevy Silverado pickup truck through the public roadways of the Satilla Shores neighborhood, and did confine and detain Ahmaud Arbery on Holmes Drive using said pickup trucks. Greg McMichael's statement: he was trapped like a rat. He was trapped between the two pickup trucks. The state has gone ahead and proven count 8. So how did that materially, substantially, and necessarily cause the death of Ahmaud Arbery? Because he's trapped between these two pickup trucks. He's right there in Holmes. He's running toward a man pointing a shotgun at him, and that man is relentless. He doesn't give up. He doesn't stay on the side of his pickup truck. So here we've got the ultimate confinement. And Judge, the ultimate confinement is death. Here he was ultimately falsely imprisoned because he was shot right there. Ultimate false imprisonment. But what they actually did is when they put Mr. Arbery in reasonable apprehension, fear of receiving bodily injury with the pickup trucks, they had him trapped like a rat. Once again, fight or flight. All he did was flee from these people. All he did was try and get away. But according to Greg McMichael, he was trapped. Greg McMichael is standing in the back of that pickup truck yelling at him, "Stop, goddammit, stop." He previously told him he was going to kill him. He was going to blow his effing head off. So at this point in time, if he had not been falsely imprisoned and trapped between these pickup trucks, he would not have been shot. The killing is the ultimate confinement. And I get that the defense is saying, well, he had options and he should have run this way and he could have run that way. Well, they're parked right in front of that driveway. They didn't actually go up to the stop sign at the end. They parked in that driveway. He was going around this side. There's a driveway to a house right there. He comes around the very front of it. They want to make it seem as if he's the one at fault for not continuing to run. He's the one at fault because they made him afraid. He's the one at fault because he didn't want to get, I don't know, it would be speculation, but nobody wants to get shot in the back with a shotgun. He's already been told they're going to kill him if he doesn't stop. So at this point in time, falsely imprisoning him there and keeping and confining him there substantially and necessarily caused his death. Blaming him for not continuing to run on or him utilizing his options to defend himself is not really, how do I put this? What Mr. Arbery chose to do in his intent is not relevant. The acts of the defendant are that's what's relevant here. And trapping him like a rat between two pickup trucks, one of which he was actively running away from as it pursued him, forcing him towards the white pickup truck and Travis McMichael and his shotgun, that was actual false imprisonment because he never ever got away from them on Holmes Drive. He was killed. So it substantially contributed to his death. when we look at counts, so we ask you to deny the directed verdict as to 4 and 8. When we look at counts 2 and 6, once again, 2 being felony murder based on the aggravated assault with a shotgun. Count 6 is did make an assault upon the person of Ahmaud Arbery with a firearm, a deadly weapon, to wit, a 12-gauge shotgun. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person. All right, so, Judge, I hear what Mr. Hoag's saying, that pointing the shotgun at him where it's up against here is an aggravated assault, and it is. And if he had never fired at him, if he'd just done that, he'd be guilty of aggravated assault. However, as you know, our Supreme Court has recently told the state, you can't go charging different moments in time in a continuous action. They've told us that. They said you can't do it. It's all one aggravated assault. There has to be an intervening factor, meaning, I think the one case that we're talking about is, it was an aggravated assault on a woman, boyfriend, girlfriend, and he went ahead and slashed her face. So we've got aggravated battery. Then there was an intervening time period where she got away from him. Then he went up and I think he stabbed her in the neck. Those were 2 separate things solely because of the intervening time factor. But the courts have said, meaning our Supreme Court has held, it's all one thing. But in this particular case, the state's not contending that it's 2 separate aggravated assaults. It's one aggravated assault when he pulled the trigger and shot him. So I just want everybody to be really, really clear. The state is arguing the state must prove that the defendant attempted to cause a violent injury to the person. And he attempted to cause a violent injury to the person when he shot him point blank in the torso with that shotgun. They are all parties to the crime of this. Because Greg McMichael's already threatened to shoot him with a, stop or blow your effing head off. Mr. Bryan sees that shotgun, sees it come out, sees exactly what's going on. We might not see it on the camera, but he's driving the truck and he's driving Mr. Arbery right towards that man with the shotgun, helping him to go ahead and commit this crime. So at this point in time, we've got the aggravated assault. Here, Travis McMichael actually pulled the trigger. Greg McMichael helped and encouraged Travis McMichael. Travis McMichael grabbed his shotgun in his driveway decision at his house, chose to bring that shotgun along, and Greg McMichael knew it. There's absolutely no evidence that Greg McMichael told him not to bring it along. Don't bring that shotgun. Nothing like that. Greg McMichael got into the truck with his son knowing he had that shotgun. This is circumstantial evidence. Greg McMichael's in the truck with Travis McMichael the entire time that he has this shotgun, both in the pickup truck, and then when Greg McMichael gets in the back of the pickup truck, Greg McMichael's yelling at Ahmaud, stop, stop. Greg McMichael's giving Travis McMichael, directions, cut him off, cut him off, cut him off. In the moment that Travis McMichael is outside, Greg McMichael can see he's got the shotgun. Stop, goddammit, stop, is what he's saying to Mr. Arbery. That is helping, intentionally aiding and abetting, knowing full well that the shotgun is being pointed at Mr. Arbery. And it's kind of encouraging. It's tacitly basically authorizing this and encouraging him, because he's not telling his son to stop doing that. You don't hear, put the shotgun down. You don't hear, what the heck are you doing? Don't do that. You hear, stop, goddammit. Travis McMichael is driving. And the one thing that's kind of important here, Judge, is that Mr. Hoag, when it came to Greg McMichael's statement, actually asked Parker Marcy a question. And it was unobjected to by Greg McMichael's counsel, but I know the court noticed it, I noticed it. It was my intention, and I know it was my son's, to arrest him or at least to get him identified. There was no objection from Travis McMichael. So at this point, what's before the court, unobjected to by Travis McMichael's counsel, is what their intentions were here. And of course, they're going to argue, well, it was to arrest him or at least get him identified. So if this is Travis McMichael's intention, it was Greg McMichael's intention, and that's what they were doing, and they were doing it at the point of a shotgun. With regard to Mr. Bryan, Mr. Bryan never called 911. Mr. Bryan continues forward recording despite the shotgun coming out. Mr. Bryan says absolutely nothing on the recording. He doesn't go, oh my God, there's a shotgun. Oh my God, what's he doing? He doesn't, like I said, swerve out of the way and into a ditch. He doesn't put it in reverse and back up so he's out of the line of fire. He pulls forward and accelerates despite the shotgun coming out. Doesn't slam on the brakes, does not protest, does not yell, doesn't honk, doesn't do anything but keep driving forward, driving Ahmaud Arbery forward. We get to this location by Mr. Bryan pursuing Mr. Arbery, because as we saw in the video, Mr. Arbery had actually run away from the white truck again. Mr. Arbery runs, we see that. He's going down homes towards Satilla. Mr. Bryan goes up and he turns around. At this point, we actually see Mr. Arbery back at the blue mailbox, having turned around, being forced to run back toward the white pickup truck. Therefore, he helped by chasing Mr. Arbery toward the white F-150 pickup truck, despite Arbery's obvious attempts to get away from the white pickup truck. But he encounters Mr. Bryan in the Silverado, so he has to run back toward the white pickup truck. Once again, a party to the crime in making this happen. And we all know that even if your finger is not on the trigger, you can still be held responsible. I mean, we all know that the getaway driver who doesn't go into the convenience store is just as guilty as the guy who goes into the convenience store and pulls the trigger, because he's there to help make it happen. Help make it happen. And here we have Travis McMichael actually pulling the trigger, Greg McMichael helping to make it happen, and William Bryan helping to make this happen. Because without their help and assistance, without Greg McMichael, especially his encouragement, Travis McMichael would not necessarily have been able to complete this had not Mr. Bryan driven Mr. Arbery toward the parked white pickup truck. If Mr. Bryan had actually kept going and up around Zellwood, or had left, Mr. Arbery would have been able to keep running up Holmes and maybe get to Zellwood and Satilla. Thus, Mr. Bryan confining him there contributed substantially and materially to the felony murder and the aggravated assault with a deadly weapon. So we ask that you go ahead and also deny the directed verdict for counts 2 and 6 of the indictment as to Greg McMichael and Travis McMichael. Did I miss anything? Okay. Thank you, Your Honor.
Any final word from the McMichael defendants on their motion?
Yes, just very briefly, Your Honor. Can you hear me from here? Citing the language in State v. Jackson, 287 Georgia 646, 2010, Georgia Supreme Court case. Justice Namias. We have also said that proximate cause is the standard for homicide cases in general. And then he cites cases and is quoting from Wilson v. State. We set out the following test for determining causation in homicide cases. Where one inflicts an unlawful injury, such injury is to be accounted as the efficient proximate cause of death whenever it shall be made to appear either that, and there are 3 subparts. 1, the injury itself constituted the sole proximate cause of the death, or 2, the injury directly and materially contributed to the happening of a subsequent accruing immediate cause of the death, or 3, the injury materially accelerated the death, although proximately occasioned by a pre-existing cause. That one doesn't apply here. So the proximate cause issue in counts 2, 3, 4, and 5 is at the heart of our motion, and I think the state's failed to make that connection between the underlying felonies that are named in counts 6, 7, 8, and 9, and the accruing death based on this test from this case. And of course, that's a completely different problem than the malice murder, and I won't say anything more about that. So that's our response to the state's, our reply to the state's response.
I'm sorry, Judge, but may I distinguish that case, having just heard it, not knowing it in advance? That case was a co-defendant felony murder case, meaning a whole bunch of people went in to commit a crime, and the victim fought back, and it ended up with one of the co-defendants murdered. So they're talking about proximate cause for the armed robbers, one armed robber being responsible for the death of his co-armed robber. That's what that case is about, not this sort of situation.
Well, I will just add that next paragraph says, consistent with this general rule, which I just read, we have held in many cases and for many decades that the proximate causation is the standard for murder cases prosecuted under the murder statute codified at OCGA 1651. The particular facts of this case are immaterial. It's the rule that I'm talking about.
Mr. Goff, on behalf of Mr. Bryan, any directed verdict?
Good morning, Your Honor. Your Honor, first thing I'll do is I'll formally adopt the very cogent arguments made by co-counsel in this case. And without tracking through those, but for Beth Brigmo giving birth to Roddy Bryan, God rest her soul, many years ago, but for that, Roddy Bryan wouldn't have been out there that day in his pickup truck. When we use this but-for causation, that there's a lot of baggage that comes along with that, and with all due respect to Ms. Dunikowski, it feels like they are stretching that term beyond recognition. The legal standard is proximate cause, and we'll come back to that in a moment, but when you look at it as proximate cause, and not simply reducing it to two words, but for, I think the court understands why the defendants are here making these motions. Your Honor, with respect to count one, malice murder, I'm really at a loss here to understand, but it was the state that decided to present what we sometimes call a kitchen sink indictment to the grand jury, where every defendant is charged in every possible way with every possible crime in this case. That was a decision the state made, and I certainly appreciate the challenge to the court in trying to assess these issues. As I look at the malice murder charge, there is no contention that Roddy Bryan shot anybody. There's no contention that Roddy Bryan tried to shoot anybody. There's no contention here that Mr. Bryan is acting as a principal. This is, if I misunderstood Ms. Dunikowski, I'm sure she'll correct me. The entire theory here is aiding and abetting, third section of that statute. And where is it that Mr. Bryan is intentionally aiding and abetting the shooting? Because he's not. Now, maybe some decision came out of the Supreme Court last week or last month that I'm unaware of. But when I went back through Kurtz last night, or it used to be called Kurtz, Offenses and Defenses in Georgia, and the section on parties to a crime, I know the court knows the treatise that I'm talking about. They list like 30 different ways that you can be a party to a crime, that you can be aiding and abetting in a murder case. But none of those are like the case before this court, which is why, although Ms. Dunikowski has cited this court well over 100 cases in oral argument, probably thousands of cases, and all the pleadings that have been filed and motions and responses going back and forth, Ms. Dunikowski cannot cite to you a single Georgia case that is remotely comparable to the one that we have before the court. This isn't the case where Mr. Bryan is driving down the street in his pickup truck and Travis McMichael is standing in the back of it shooting at Mr. Arbery. This isn't that case. There is no case, and she can cite no case remotely close to this one. The closest cases that I've been able to find, and of course they're referenced in there, in what I call the distraction aiding and abetting cases, in which one person intentionally distracts another person while someone else behind them either takes a knife and stabs them with it or shoots them. I call them distraction cases, where you're aiding and abetting by distracting. There is no evidence and no suggestion here that Mr. Bryan's conduct has somehow distracted Mr. Arbery. He's well aware of the pickup truck in front of him from the video. He's well aware from the video that they are both armed. So, and Mr. Arbery is not shot with his back turned. That might pose a different and a closer question for the court. But in this case, unless Ms. Dunikowski can cite some Georgia case suggesting this, which I still don't understand, theory of aiding and abetting the shooting of Mr. Arbery, there simply is no malice murder case here. And, you know, co-counsel points out some pretty good cases on what the mens rea is required here. Where is any of that for Mr. Bryan? There's no malignant heart in this case. There's nothing from which that could be presumed. And, you know, that takes us back to the whole concept of a citizen arrest. If I understand the state's theory here, the state contends that the McMichaels, and I believe they're contending that Mr. Bryan was assisting them or aiding them in attempting to make a citizen's arrest, which in the opinion of the state was not authorized under Georgia law. And that may be true, Your Honor. But the fact that Mr. Bryan aided and abetted a citizen arrest, if he did that, doesn't establish malice in this case. It doesn't establish an intent to aid and abet an intent for a shooting. You know, and Your Honor, I would urge the court to ponder the larger implications of the legal ruling that the state is requesting here. Because in this one case, it might serve the interests of the state. But in the larger question, if 10 police officers respond to a call, 10 police officers pull their cars up around a scene, and they're there, maybe they're still moving, Your Honor, and inexplicably, a police officer discharges his weapon and shoots the person that they're after in the head. Maybe they had probable cause, maybe they didn't. But are we going to try every police officer who's present at the scene of an attempted arrest for malice murder because somehow in aiding and abetting an attempt at an arrest, lawful or unlawful, that translates into aiding and abetting the shooting that follows? That can't be the law, Your Honor. And we shouldn't be creating special rules of law. There are already enough of those. We shouldn't be creating any more special rules of law for one case, because we know the reality is that these things have unintended consequences and they take on a life of their own. We don't need to start down this theory that anybody who's attempting to arrest someone, which after the last legislative session is pretty much limited to police officers, that anytime police officers are attempting to arrest somebody, particularly if they're attempting to do so unlawfully, that they're aiding and abetting the arrest, lawful or unlawful, is aiding and abetting a shooting or other unlawful use of force that follows. There is no malice murder case as to Mr. Bryan. There is no authority for this case. Your Honor, the state wants to talk about but for. I want to talk about intervening factors. And before I do that, Your Honor, I would, maybe it's just me. Maybe I'm just not smart enough to keep up this Dunikowski here, but the way Ms. Dunikowski is presenting this malice murder argument to the court is, in essence, collapsing malice murder into felony murder. What distinction is left here between malice murder and felony murder when Ms. Dunikowski makes these arguments? Because it's winding up being the same thing. Well, you know, he intended to shoot, therefore he intended to kill. Or he intended to falsely imprison, he must intend to shoot. How do we distinguish at the end of the day with the arguments made by the state between malice murder and felony murder? Your Honor, this is a case, and this feeds into the severance issue. And with all due respect to Ms. Dunikowski, I would humbly suggest to the court that if Ms. Dunikowski continues to proceed along this line with malice murder, and we go into the defense case here, we are going to have, at some point, antagonistic defenses that cannot be overlooked. The state, as I understand it, has not submitted a charge on manslaughter. My understanding that learned co-counsel from the McMichael defendants has not submitted a jury charge on manslaughter. And part of that, I think, well, there's different strategic reasons why people do things, but my point to Your Honor is, in terms of proximate cause, do we not have not one, but two intervening factors here? Factors that are not reasonably foreseeable to Roddy Bryan. Maybe logically foreseeable in something that's conceptually possible, but not reasonably foreseeable in the sense that the law would imply. You have in the video, and unless I missed it, This part of the video, the state contends, is undisputed, uncontradicted. In the video, at the last minute, you see Mr. Arbery, instead of turning right towards the exit of Satilla Shores, he turns to the left. Now, it's not for me to judge or question why Mr. Arbery does the things he does, but when he turns left instead of right, regardless of his justifications or his reasons for doing so, that is an intervening cause, an intervening circumstance, I submit, under Georgia law. And at that point, it's not foreseeable to Mr. Bryan. It's not foreseeable that just like on the street with the police officers, suicide by cop is not reasonably foreseeable, nor is suicide by citizen's arrest. When Mr. Arbery turns towards Mr. McMichael, that is an intervening circumstance that breaks any causative chain here with respect to the shooting and death itself. Likewise, and I'm certainly not taking sides in this. It'll be for the jury and for the court to determine the guilt or innocence of the McMichael defendants. But at the same time, you have a second intervening factor. The first intervening factor is Mr. Arbery pivoting to the left instead of heading for the exit. The second intervening factor is Travis McMichael discharging his weapon. And I'm not questioning why Mr. Arbery is doing what he's doing. I'm not questioning why Travis McMichael is doing what he's doing. But what I'm saying is you have a second intervening factor, which is the choice of Travis McMichael to discharge his weapon. It doesn't really matter for purposes of evaluating count one malice murder if the court can see that whoever's in the right here, whoever's in the wrong, whichever party is using excessive force, maybe both parties are using excessive force, maybe there's some kind of mutual combat theory to be had out there. But from Mr. Bryan's perspective, in terms of proximate cause, in terms of what's reasonably foreseeable to him, none of these things are reasonably foreseeable. And I think the court understands the consequences if the court were to go down any other road. And if we're going to persist with this issue, we're going to wind up in a severance posture. It may be premature. We haven't heard whether any of the other defendants have testified yet. But I would submit the easiest way to resolve the severance issue is to grant the motion for directed verdict for Mr. Bryan as to malice murder. Moving on to count 2, felony murder, which is tied to count 6, aggravated assault to a shotgun. Again, the arguments come down very much the same way, because the state's position on malice murder is essentially, although not in so many words, collapsing into felony murder. Where is the intent on the part of Mr. Bryan to facilitate an aggravated assault with a shotgun? Again, it's one thing to say, if the state contends that's what the evidence shows, that Mr. Bryan is attempting to assist in a citizen's arrest, aiding and abetting a citizen's arrest. But there's nothing reasonably foreseeable about killing someone in a citizen arrest. Just as on the street, there's nothing reasonably foreseeable to police officers when a fellow officer, without cause, discharges a weapon, in these days maybe even a taser, and kills somebody. Again, there is no proximate cause, and there is no mens rea, there is no aiding and abetting the shooting. Now, Ms. Dunikowski wants to make a big deal of the fact that the gun is visible, that Mr. Bryan's truck is still moving, although obviously at a slow rate of speed, and therefore because he doesn't run in a ditch or he doesn't back up, that he somehow is now joining in the shooting. But again, I understand that the state's position is pretty clear, almost uncontradicted, that this is a purported attempted citizen arrest. Again, in the context of a citizen arrest, is the fact that Mr. Bryan is maneuvering his truck, and positioning his cell phone to follow Mr. Arbery and document what Mr. Arbery is doing. How does that circumstance, whether he's traveling at 2 miles an hour, 4 miles an hour, or 6, how does that establish his aiding and abetting the shooting itself? Because Mr. Bryan only has knowledge of the existence of the weapon, as we see on the video, at the very last moment. And still, at that time, from Mr. Bryan's perspective, even if he's attempting to aid and abet a citizen arrest, that's not the same thing as aiding and abetting a murder. I mean, would it be it's the same thing, Your Honor, whether Travis McMichael is shooting him or not, or whether he's pulling out a club and beating him on the side of the road with a billy club like a police officer would do. Again, How is Mr. Bryant's assisting, if that's what it is, in a citizen arrest, showing that he's attempting to aid and abet the shooting, aiding and abet an unlawful, excessive use of force in the making of an arrest? That's just not there. That's just not Georgia law. And again, the state says the jury should consider the fact that they had their guns drawn. Okay, well, how is Mr. Bryant, again, to know that they have any intent in drawing a weapon, whether it's in the down position, the up position? I'm not a use of force expert, but whatever position. Again, how is that telling Mr. Bryant that they intend to use excessive force, that they intend to kill him, that they're not trying? Maybe that's the state's theory, that they weren't really trying to make an unlawful arrest. They were just looking for an excuse to kill him. Or they were just waiting for the opportunity, notwithstanding the fact that they've had lots of opportunities to shoot this gentleman over 5 minutes. He's clearly, in terms of proximate cause, when you look at the video, you see Mr. Arbery. He's well within range. He's well within shotgun range. He's also well within range of Greg McMichael's handgun at the time that Mr. Bryant is pulling up. From Mr. Bryant's perspective, he didn't have any reason to think they were trying or intended to hurt these people. They had ample opportunity to do that long before he got there, long before he pulled up. Again, I'm asking the court to grant a directed verdict on count 2, felony murder based on the underlying count 6, aggravated assault with a shotgun. Count 3, felony murder, aggravated assault with a pickup truck. Your Honor, although the statute defines the grounds for a directed verdict, I believe Ms. Dunikowski has acknowledged that it's not that simple, that the standard essentially goes back to Jackson v. Virginia. It's not just whether there's quote unquote any evidence to submit something to a jury. There has to be sufficient evidence from which a rational juror could find guilt beyond a reasonable doubt. There is a severe lack of evidence in this case. There's no evidence that Mr. Bryant intended to do so. What they're doing is they're basing that on words, and I'm going to incorporate here for purposes of the motion for directed verdict the arguments made in connection with the special demurrer in this case. And of course, those have also already been addressed to some extent by counsel for the McMichaels. Your Honor, there's no witness. There is no witness to what Mr. Bryant did. There's no video of an aggravated assault. It's all contradicted by the physical evidence in this case. And I don't have the citation in front of me, but with respect to aggravated assault with a motor vehicle, I think the case law, there is a case specifically out there that says speculation as to aggravated assault is inappropriate. And there are some times when there's insufficient evidence and where the jury is basically being asked to speculate as to what happened. And this is that case, Your Honor. And with terms of felony murder, again, you get back to the same issue. Assuming for the moment that Mr. Bryan was committing an aggravated assault with a pickup truck down on Burford, how does that establish, how is that the proximate cause of a felony murder that takes place down on Holmes Street later? And for the jury to be able to return a verdict, because of the way this indictment is phrased, the jury can return a verdict of guilty without specifying where it takes place. How do we know that the jurors, certainly all 12 of them, have made a decision as to that? Because without that, how can they make a determination as to proximate cause? This is a huge problem. And I'm going to get back to count 7 in a moment. But in terms of felony murder, there's just no proximate cause here. It's not reasonably foreseeable. And it's a huge stretch to say that what Mr. Bryan is doing out there in his truck is causing the death. In fact, I think the McMichael lawyers have already pointed out that their truck is stopped. It's not even moving. And Ms. Dunikowski talks about revving the engine, but I think the video speaks for itself. Certainly Mr. Arbery is not assaulting at this time. Your Honor, there's no proximate cause. There's insufficient connection to the death. I'm going to turn to count 4, felony murder, which is based on false imprisonment. Your Honor, I do believe that there was a special demurrer filed in this case previously, about false imprisonment. And if I recall, the court cited a case, and I don't have it in front of me, about you can imprison with a pickup truck. My recollection of that case was a case where not just where someone was being chased, but where they actually were struck and went over the hood, and then the person in the car got out and did a stabbing. That's certainly factually distinguishable. But again, what is it if the false? At the time of the shooting, there is no false imprisonment, Your Honor. At the time of the shooting, Mr. Arbery, to borrow a football phrase, has broken containment. He is past both trucks at that point and has a clear line to the exit to the neighborhood. So I don't understand how you can have proximate cause between a false imprisonment, if that's what it is, and the shooting itself. Because there isn't. I'd also contend, notwithstanding Georgia law to the contrary, that false imprisonment is not the kind of felony that will support a felony murder charge. There are other jurisdictions that disagree with Georgia, and under their laws, they do not view false imprisonment as a violent offense that would be a felony you could base a false imprisonment on. I certainly want to preserve that argument. Because it's just, I guess the best way to phrase it in terms of Georgia law is false imprisonment really is more like a status offense than it is a violent offense. And in that respect, it should not be the underlying felony for a felony murder charge. We still have issues with the mens rea. We still contend that the false imprisonment is unsupported factually. But again, in terms of foreseeable, how is the shooting, Your Honor, reasonably foreseeable to Mr. Bryant, assuming that there is a false imprisonment? How is the shooting itself? It's one thing to say that Mr. Bryant aided and abetted a false imprisonment. That's not the same thing as saying he aided and abetted a shooting. And that, again, goes back over ground I think I've already covered, and I won't do that to the court again. Count 5, felony murder. Again, we contend that criminal attempt to commit felony murder is not the kind of offense upon which a felony murder charge can be predicated. We would suggest to the court that is even a step further removed from false imprisonment itself, and that furthermore that the attempted false imprisonment is not the proximate cause, again, of the shooting or death of Mr. Arbery. There are real problems there with a causal link. Count 6, aggravated assault with a shotgun. Again, there is no aiding and abetting for Mr. Bryant. Aiding and abetting a citizen arrest, even if unlawful, is not the same thing as aiding and abetting a shooting. And I won't go back down that ground any further. Count 7, aggravated assault with the trucks. Co-counsel has already spent a good bit of time addressing this. I've addressed it in the special demurrer. It's troubling to me that the state comes in here when 3 police officers, Your Honor, 3 seasoned police officers, well, 2 well-seasoned, 1 we could argue about, all interview Mr. Bryant, and that's the basis of this count, is Mr. Bryant's statements himself. There's no other evidence other than that in this case. And all three of these officers interviewed Mr. Bryant or talked to Mr. Bryant at length. All 3 summarized those interviews. None of them refer to Mr. Bryant's conduct as an aggravated assault. None of them do that because it's not there. The jury, Your Honor, is required to get to the truth of the matter. It's not just the words that Mr. Bryant uses, anybody's words can be twisted out of context. It's the context in which they're given. It's the meaning that's meant to be conveyed. And it's clear from the testimony of the state's own witnesses that that meaning is not there. There is no aggravated assault with Mr. Bryant. And I'm jumping back and forth here, I guess, make sure where I am. Your Honor, the evidence is, in terms of the speed, for example, that while the state refers to Mr. Bryant as chasing, that the evidence is on the video is at 2 miles an hour. Your Honor, with respect to count 8, the false imprisonment, the indictment alleges, and the state is stuck with the language in the indictment, that that the confinement and detainment occurs on Holmes Drive. But the evidence that the state is relying on is coming from Burford, and he can't be convicted at this point of that. And how the court would charge the jury, I have no idea. Your Honor, on count 8, the false imprisonment, I talked earlier about the breaking containment. There is some Georgia case law out there, and for example, I guess this is the best analogy I can come up with here. In a bank robbery, when an individual committing a bank robbery pulls out a gun and tells everybody to get down on the ground, under Georgia law, that is a false imprisonment because they get on the ground. But this case isn't the case where they get on the ground. Mr. Arbery never submits to being arrested. And in this case, this is what the state is pursuing here is the equivalent to someone in a store saying, everybody get down on the ground, and the person just continuing to run right out the door. That's what we have here, and that is not a false imprisonment under Georgia law. And again, if Ms. Dunikoski has a case citation for this court to any Georgia case that is remotely factually close to this one, I'm sure she'll present it, but I can't find it. Your Honor, attempted false imprisonment, that's count 9. We contend that the evidence is simply insufficient to submit that matter to the jury. Moreover, we think the evidence that was presented during the state's case in chief shows affirmatively abandonment. That Mr. Bryan has abandoned this chase, as they call it, and the video itself, I think, demonstrates that at the time of the shooting, Mr. Bryan is simply a witness to the shooting itself and to those events. And under those circumstances, we believe that he is entitled to have an acquittal as to count 9 and all the other counts in this indictment. We would ask that a directed verdict be granted on all counts and that Mr. Bryan be released forthwith.
Before the state responds, could we break briefly for restroom?
Yeah, it's going to take a 10-minute recess. So let's go ahead and take 10 minutes. We'll reconvene at 10 of. Thank you.
Please leave, please.
All right, we are back on. Defendants present from the state.
Thank you, Judge. Mr. Goff talked a lot about citizen's arrest, and that being the defense in this case, but there hasn't been any evidence that anyone was making a citizen's arrest. Citizen's arrest was never said by any of these 3 defendants at any point in time. The evidence that's been presented is that Mr. Bryan and Mr. Greg McMichael never once said, we're making a citizen's arrest, that we're placing him under the arrest for the crime of this, that we saw him commit a crime that day. That was not it. It was all, we wanted to stop and talk to him, and then we wanted to detain him. In fact, Mr. Rubin said in his opening statement that the intent was to detain him so that the police could show up and do whatever they were going to do after the detention. It's not citizen's detention, it's citizen's arrest. So while he talked about that, that is really not something to be considered in a directed verdict motion. And just because a set of facts hasn't yet been specifically identically brought before a court, these sets of facts, no 2 cases are going to have the same set of facts. They're just not. And so the fact that there is felony murder based on false imprisonment case law out there, where someone has been found guilty of felony murder based on false imprisonment, someone's been found guilty as a party to crime based on aggravated assault with a shotgun, someone's been found guilty of party to a crime for aggravated assault with a motor vehicle. Those cases are out there, maybe not with these specific facts. So that argument doesn't really hold water either. In this particular case, when it comes to Mr. Bryan, and this will apply for all of the charges here, once again, it's party to a crime, and that means intentionally aid and abet. His statements to Agent Seacrest and actually at the scene to Officer Minshew were about, I thought they had done something, I thought I was trying to help them get this guy, false imprison this guy, capture this guy. And that was what his intent was. It was to falsely imprison this particular person, and he intentionally used his vehicle to go ahead and do that. Both on Burford, when he intentionally committed an aggravated assault, putting Mr. Arbery in reasonable apprehension of receiving serious bodily injury as part of his attempt to falsely imprison him on Burford. Those two things contributed to his death because but for those things happening, Mr. Arbery would still be alive. So it is, as the pattern charge will be given, his actions played a substantial and necessary part in causing the death, because without him doing those things, Mr. Arbery would not have been trapped like a rat over on Holmes Drive between the two pickup trucks. As we noted before, malice chased him through the public roadways in the pickup trucks, tried to stop him, cut him off with the pickup trucks. He drove him into a ditch. He assisted pinning him between the two pickup trucks, trapping him like a rat between the two pickup trucks. Mr. Arbery had not threatened anybody, had shown no aggression. Mr. Arbery had no weapons. He was totally unarmed. And here, Mr. Bryan never called 911. He continues pursuing Mr. Arbery. Mr. Bryan never says anything on the recording. He pulls forward despite the shotgun coming out, despite the shotgun being pointed at himself, doesn't slam on the brakes, doesn't yell, doesn't protest, doesn't honk, just keeps driving forward, driving Mr. Arbery forward. He helped to get Mr. Arbery to this location by redirecting him up Holmes. The most important thing is when you have common criminal intent, and here the state's position is that as parties to the crime, there's common criminal intent to attack Mr. Arbery via false imprisonment, aggravated assault with the pickup trucks, aggravated assault with the shotgun, and false imprisonment ultimately on Holmes. And that common criminal intent to do all those things, not necessarily the conspiracy. I'm not talking about conspiring in advance and coming up with a plan as we sit around the kitchen table. We're talking about what they actually did, acted in concert with each other. The white truck came down Holmes. Mr. Bryan was going up Holmes. Mr. Arbery had already turned around and was running back, and the white truck passed him. Mr. Bryan did not abandon this. He turned around. He kept going, and then he accelerated to catch up to Mr. Arbery, passed the blue mailbox, saw the shotgun, and kept going. Common criminal intent, which resulted in malice murder, resulted in all the felony murders. All of his actions did substantially contribute to the death of Mr. Arbery, and they were necessary because without those actions, Mr. Arbery would be alive. We ask that you deny the directed verdict for all of the counts as to Mr. Bryan. Thank you.
Any final word from Mr. Bryan?
Your Honor, when the state is constrained to acknowledge that they have no legal authority for their position, for example, on malice murder, then I think the court should take seriously the motion to grant the directed verdict. There is no malice murder case against Mr. Bryan. With all due respect to the state, there never was. That there are some other issues in the case that are more challenging and more troubling, but that's an easy call. I think it's an easy call on count 2 felony murder for Mr. Bryan only. Again, the state has no fault. It doesn't even pretend to give an explanation as to how Mr. Bryan, thinking that he's aiding a citizen arrest lawfully or unlawfully, how that translates into an intent to shoot or an intent to injure. And it's deeply troubling to me that the state can't have the candor to acknowledge to the court that maybe in retrospect, counts 1 and count 2 as to Mr. Bryan were not well thought out. There's no proximate cause. There's no reasonable foreseeability here. I'm impressed with the argument that was made, but still, Mr. Bryan is entitled to a directed verdict, certainly on count 1, almost certainly on count 2, and arguably as to every count in the indictment. Thank you.
And profusely. I had pulled up the case and I forgot to cite it. And it is both the state of Georgia, well, Moore versus the state and Milburn versus the state. It is 311 Georgia 506. And in this particular case, a group of men wanted to rob a drug dealer, and one person stayed downstairs to keep the boyfriend away while they went up to go ahead and search the apartment. Unfortunately, the girlfriend was in the apartment, and the two that went up there, one executed the girlfriend. They came downstairs. The state obtained a malice murder conviction on the man downstairs who simply kept the boyfriend from protecting the girlfriend upstairs. And that is a case that does show someone who doesn't have their finger on the trigger, who's downstairs doing some other action, the same sort of criminal intent, which we feel that's here, same criminal intent to falsely imprison, aggravated assault with the trucks and with the gun, can be convicted of malice murder. And that's the case we cite to. I apologize for not having brought it up further earlier.
Mr.
I'm
Croft.
sorry, was there a citation for Milburn, or are we abandoning that at this point?
No, Moore and Milburn are co-defendants, and it was a combined case, and
Okay.
so it is the same case. 311 Georgia 506 out of Cobb County, 2021.
Again, Your Honor, that case doesn't even get close here. That is in line with the other cases, what I call the distraction line of cases. It's basically the same thing. In this case, it's distraction plus, in that the person who's being charged is holding, basically, a third party who could otherwise and would otherwise go to the defense of the person who's killed. Mr. Bryan is sitting out there in his truck armed only with a cell phone. He's not holding anybody back. He's not saying, Mr. Albenza, you stay back there. There's nobody else on the scene. This is a case where someone is actively preventing this. Moore v. State is a case where someone is actively preventing a third party from coming to the aid of the person being killed upstairs. That is completely irrelevant and totally off base. And again, Your Honor, if that's the best the state can present to the court, then I think the court is constrained to grant the directed verdict as to count one.
All right, I've heard the arguments and presentation of counsel on the motions for directed verdict under 1791A. The court, considering the appropriate standard after the state's rested, is denying the motions for directed verdict of the McMichaels defendants, the collective motion made by Mr. Hogue, as well as Mr. Bryan's motion for directed verdict as presented. The court also has the demur to address. So the court, having reviewed the demur, it looks like it does raise a slightly different issue than what had been presented previously in the demurs that have been filed, specifically the contentions that count 7, and this is paraphrasing, combines multiple violations or different violations under the same statute in a variety of ways with numerous defendants. This is the allegation. In such a manner that cannot be reasonably counted at trial. And I've reviewed count 7, which does apply to all 3 defendants. It's the aggravated assault. In this particular case, the defendants are charged as parties to a crime. Having reviewed the language of the indictment itself, it is in the conjunctive. Court, looking at cases such as Moore v. State, 319 Georgia App 696, and Straker v. State, 259 Georgia App 904, as well as Muhammad v. State, 307 Georgia 89. After considering the submission of counsel as well as arguments made, denies the demur. The next matter I have before the court is the defendant's presentation of evidence and choice to testify. So what I'm planning to do is get into Mr. Bryan's opening statement and then get right into evidence. I'm assuming we would start with Travis McMichael, or I didn't know whether there was going to be a combined presentation. Has there been any discussion about that?
Joe, we're going to begin with our witnesses, and so to the extent that they serve both Travis and Greg McMichael, they may or they will. And I think that we will be handling all of the witnesses for that joint kind of presentation.
I'm just trying to think of how that then is presented as we get started with the jury.
And it would probably be something to the effect of we rest, and then if
And
the
adopts.
Hogues, if the Hogues need to do anything, then they could, or they would just say we also rest, and then Mr. Bryan.
Okay. That makes sense. I understand how we'll present it then. Then I guess with that being how we're going to move through this. Go ahead, Mr. Goff.
Your Honor, we do have two matters to put on the record before we bring the jury back in.
Let's get through what I'm trying to get through then. What I'd like to do then is, has there then been discussion, counsel for Travis McMichael, about his right to testify and his intent with regard to testimony in the court?
Yes, we've discussed with him that he has the right to testify or not. He has expressed to us that he understands that very clearly, and he will elect to do so or not do so. The court certainly can inform him that he has the right and that he's presumed innocent and all that, but we've discussed that with him already.
All right.
The court just wants to make sure he's informed, right?
Right, I want to make sure he's informed. So generally what I'll do is swear the defendant in and walk through a few questions to make sure that I'm comfortable with his understanding of what his rights are, since it is his decision and his decision alone to testify.
Right.
So that's the court's general course. We can do that. I guess what you're saying is at this point, no decision's been made, or there
Yeah,
has been?
we're asking the court not to ask him if he's going to testify or not, but the court can inform him of his rights.
Okay. Well, I might have to circle back then as we get into the evidence, just to make sure that I'm clear about where we are, but I would like to generally make sure that that discussion has occurred.
Yes, Your Honor, the same thing. We have made Mr. McMichael abundantly clear, and of course, he already was aware of his rights, the dangers, the pros, the cons, and he understands that it is his decision to make, but we would not be allowing, respectfully, the court to inquire of him of that decision until he's made that decision. He'll either take the stand or he won't, and that will inform the court and the rest of the folks of what decision he's made.
Well, I might wait then to swear the defendants. My understanding then the well, no, let me just do this. I'll make it a much more general inquiry then, just to make sure that the defendants have had that opportunity. If they wish to take any additional time, they can do so. All right. All right. Let's do that then. What I'm going to do is just swear each one of the defendants in for the limited purpose that I just described, and we should move through this relatively quickly. So, if I can get all three defendants just to please stand. Swear to tell the truth, whole truth, and nothing but the truth. I do. I do. That's a yes or no? I do. Okay. All right. Travis McMichael. Just want to make sure that you understand before we get started that I have no opinion on this whatsoever. The only reason that I've sworn you in this morning is to make sure that I have a understanding of your knowledge with regard to your right to testify in this court. I'm going to ask you some questions. None of those questions are intended to ask what specifically you have discussed with your lawyers. You have a privilege with your lawyer. I want just some basic understanding of what you know about your right to testify in this court. Do you understand that?
Yes, Your Honor.
All right. What is your highest level of education?
12th grade, graduate high school.
All right. And I understand you have already spoken with your attorney already about your right to testify in this court.
I did.
And you understand that you do have a right to remain silent in this court?
Yes, Your Honor.
And what that means is that you have the right not to take the stand and testify, and nobody can make you testify in this court. Do you understand that?
That's correct. Yes, sir.
The right to testify in this court before this jury is your right, and therefore it ultimately is your decision and your decision alone whether you do or do not testify. Do you understand that?
Yes, Your Honor.
No matter what your lawyer may have told you, and again, I don't want to get into any of that, ultimately it's your choice.
That's correct.
You understand that if you do testify, you'd be treated like any other witness in this court, which means that not only would you be able to testify on direct examination with your counsel, but you would be subject to cross-examination by the state.
Yes, sir.
Do you need any additional time to speak with your lawyer about your right to testify in this court?
I do not.
All right, thank you, sir.
Thank you.
Thank you, Your Honor.
Mr. McFarland. Again, I have no opinion either way. You understand that. I won't go through all that prefatory that I just did with Travis McMichael. Again, I'm just trying to ensure that you understand what your rights are before this court. With regard to your education level, what's your highest level of education? Okay.
Some call.
And I understand you have already spoken with your attorney already about your right to testify in this court.
I have.
You understand you do have a right to remain silent,
Yes, sir.
and that what that means is you do not have to take the stand in this court. And I probably should have mentioned when I was going through this with Travis McMichael, if you choose not to take the stand in this case, the court will instruct the jury that they can't hold that against you in any way. Again, lawyers, you've had this discussion with your lawyers. You understand, though, ultimately is your decision and your decision alone whether or not you do or do not testify in this case.
Yes, Your Honor.
And have you had a full opportunity to discuss the matter with counsel?
Yes.
Do you need any additional time to speak with counsel?
Yes, sir.
All right, thank you, sir. Mr. Bryant. Again, what is your education level?
12th.
And again, you do understand that you have a right to remain silent in this court,
Yes, sir, I do.
that you cannot be compelled to testify before the panel if you don't wish to.
Right, yes, sir.
You can testify before the panel, you understand that?
I understand.
And the decision to testify or not testify is ultimately your decision and your decision alone,
Yes, sir.
no matter what you may have discussed with counsel.
Yes, sir.
And did you have a full opportunity to discuss with counsel your right to testify before this court?
We have.
And you understand that if you do testify before this court, you'd be treated as any other witness, which means that the state can cross-examine you.
I understand.
And you understand that also if you choose not to testify, the court will instruct the jury that that cannot be held against you in any way. Do you understand that?
Yes, sir, I do.
Do you need any additional time to speak with counsel about your right to testify in this court?
No, sir.
Thank you, sir.
Thank you.
All right, Mr. Goff, you indicated you had 2 matters before the panel comes back.
Yes, Your Honor. Since we last broached the subject, I would note that an individual that matches the general height and build of Pastor Mark Baker, a local pastor, I believe in jury selection, he was referenced by one of the jurors or potential jurors as having had the Attorney General of Georgia, Chris Carr, as a guest at his church where this case was discussed. I saw what I believe was that young gentleman, a pillar of our community, I would add, in the back of the courtroom yesterday. And I can't say that I see him now, but I thought I saw him out in the hallway. I would also note it's unclear whether he is a member of the Community First Planning Commission, one of the 21 black pastors. Of course, that is not just black pastors. There are other white pastors who've been in and out of the courtroom. I believe yesterday afternoon, I could be mistaken because I've never had the pleasure to meet her personally, but I believe our local rabbi, a white female, who's also been active in the social justice movement here, for lack of a better word, was present in the back of the courtroom. Given the court's rulings, and I'm not questioning the rulings of the court, of course, we're unable to document who actually is in the back of the public gallery, in the back of the courtroom. But then this morning, I believe, as much as I'd like to see him, I regret the circumstances, the Honorable Right Reverend Jesse Jackson is here yet again in the back of the courtroom. And there has been no indication yet from the state or anyone else that he is actually here in a capacity as a minister, given his remote location from this area. I am, again, separately and independently from any of the prior motions for mistrial, moving for a mistrial in this case. Again, the developments of yesterday afternoon and today, in conjunction with all that has gone before, reasonably called into question whether the defendant Brian can receive a fair trial in this matter, notwithstanding the best efforts of this court to ensure one. And we are therefore moving for, again, for a mistrial.
Anything from the remaining defendants?
We're not joining on mistrial, Your Honor, but I think that it's prudent to recognize the limitations that the court set for who will be sitting in these rows, and that we do have the overflow room for the general public. I think it's been made abundantly clear that the people who are joining the Arbery family are part of a larger conversation that is happening nationally, that has been funneled down into the community, and so they represent a national conversation that is for the conviction of the defendants. And for that reason, I think that they should not be present in the courtroom where the jury can see them and be reminded of the national conversation. That is an improper influence on the jury to the extent, and I'm sure that they would recognize throughout the course of their lives, that they have had this type of impact on communities nationally and locally. And for that reason, I think it's more prudent to have them join the public in the overflow public room so that the risk of influence isn't present. Thank you.
Greg McMichael joins Travis McMichael's motion.
That would be the remedy that we're seeking.
Anything from the state?
There's absolutely no evidence that these jurors are aware of any national conversation about the conviction of these defendants. So to say that this is having an influence on the jurors assumes facts absolutely not in evidence. The assumption that there's some improper influence because some people are sitting in the back of the courtroom, there's been no evidence of that. And we leave it to the discretion of the court, Your Honor.
All right. The court's denying the mistrial. I address Mr. Sheffield's point. During jury selection, these particular members of the panel, the entire panel, I should say, that was before the court over 3 weeks was extensively, I don't want to say examined because that makes them sound like witnesses, and I've equated that before, but they were asked quite a bit about their backgrounds as part of the vetting process for this jury. And in fact, a lot of that went further than this court may have thought necessary, but it did delve deeply into many beliefs that they have about what is going on in this community, as well as with regard to organizations such as Black Lives Matter and various other things. So that has been vetted through the court, and I'm comfortable that that process has resulted in a panel that is willing to listen to the evidence and only the evidence that is presented in this courtroom. I've already ruled upon the presence of certain individuals in the court. I'm not going to go back over that, but I'm denying the mistrial for the same reasons that I've done before. I will note that the court has put restrictions on what folks can actually wear in the courtroom. We're not doing any buttons or face masks or anything like that. Everybody is here complying with the court's orders. There is also a order in place that governs seating in the courtroom and seating in the overflow room. And as far as I'm concerned, that has been complied with. That's the court's order that I put in place about a week, maybe 2 weeks, could have been longer before the trial started, to help address some of the concerns that were voiced prior to trial. So since everybody's complying with this court's orders, and since the court is comfortable that we have a panel in place that will listen to the evidence that is presented and not be influenced by factors that may or may not be appearing in the courtroom, and I'll note, just so that it's clear, I believe that the Reverend Jackson is in the courtroom. With all due respect to whomever Mr. Goff was addressing before, I don't know who that is, but the court's position, I think, has been made clear. All right. Are we ready to get the panel?
Not quite. Second motion, Your Honor. And that is a motion that relates back to issues that were discussed by the court with counsel before the trial started, I believe. And this motion is based on the developments during the trial of this case. We don't think the record is, at this point, adequately documents whether jurors have been contacted or otherwise exposed to improper influences. I think that it's probably at this point insufficient to just let the jurors bring matters to the attention of the court. It's probably something for the balance of the trial the court should consider inquiring on the record, or however we're going to do that to preserve the record. You know, when we actually prepared the written motion that was filed on the matter the court's already addressed this morning, the ingenuity with which individuals over time, from the anti-civil rights organizations to organized crime to whatever, there just seems to be so innumerable ways to influence jurors. Sometimes they're not even aware of it. Sometimes it's not even clear till after the fact. We think the court, it's incumbent on the court to better document the situation with the jurors on a daily basis. And in support of that, you know, I would start by go ahead and tendering as an exhibit. I was kind of surprised it didn't come up during Officer Rash's testimony, but he wasn't my witness. Madam Court Reporter can mark this as whatever exhibit next is for Mr. Bryan, and I'm going to provide a copy to opposing counsel. Hopefully there'll be one left for me when I'm done. Your Honor will recall the testimony of Officer Rash at the very conclusion. I believe it was the last question or two on redirect from Ms. Dunikowski. She asked Officer Rash whether there was some litigation and whether it would affect his testimony. And of course he said no. And of course he's subject to recall, and whether we go back to Officer Rash or others go back in rebuttal is not for me to say. But there is in fact a federal civil lawsuit involving Officer Rash and defendants in this case, as well as District Attorney Jackie Johnson and Waycross District Attorney George Barnhill, filed by Wanda Cooper in her individual capacity as administrator of the estate of the decedent Ahmaud Arbery. That complaint, and it's copied, you're reading left to right instead of right to left on the page numbers, Your Honor. But basically, this is a lawsuit that spans 45 pages and approaching 300 paragraphs. Your Honor, it is a suit essentially making claims that are substantial. I would also note, and we certainly can try and print stuff online, I think it's pretty much common knowledge at this point, at least in Brunswick, that the 223 Foundation raised or claims to have raised $2 million for the estate of Mr. Arbery.
Where are we going with this?
I'm going, Your Honor, that this is a case in which there are a lot of resources out there, and there's a lot of things in play, and we think that, for example, the same lawyers involved in this case just settled for $27 million a lawsuit involving George Floyd. There's a lot of money floating around out there, and I'm not saying that anybody's using that money improperly. I haven't alleged that. But I am suggesting that under the circumstances of the case, that it would be appropriate to heighten at this point, based on the developments as the case has progressed, the court's inquiry or protection of the jurors from improper influence. I would note that none of us, including the state, no one has asked to sequester this jury. And I'm not asking the court to do that now, but we do have an unsequestered jury. And I think that under the circumstances, given the history in the George Floyd case, and I don't mean any disrespect to Mr. Floyd, I guess technically I should call it the Chauvin case, you know, issues arose, things that came out after the fact involving, I believe, one of the jurors, issues involving elected officials consciously or unconsciously, perhaps influencing a sequestered jury's verdict. I think there's enough basis in this situation, and given the developments during the trial and what is anticipated to be a massive event outside the courthouse in the morning, that the court step up the efforts taken by the court to ensure the sanctity of our jury process. These jurors have certainly never been exposed or involved in a case like this before. So I've made my motion.
This is the same motion that was made by Mr. Home earlier in the case. The court initially indicated that we use that process, but the court and I informed counsel that I'd reconsidered that process and that I was comfortable with the way the court has been moving forward here, which is every evening before we break, making very clear and repeating the court's instruction with regard to any outside influences and asking that they would be reported immediately upon their return. I have not received any of that from the panel, and the court's position remains that there are safeguards in place to ensure that that is not occurring. I understand counsel's concern, and that is the reason we're asking, or I'm telling them every night, what the court's specific instructions are with regard to any outside influence, discussion in the case, picking up newspapers, addressing social media, addressing anybody talking to them, addressing anybody actually speaking in their presence of hearing, and reporting that back to the court. That's why they received that instruction. So the court intends to proceed that way.
And for the record, text, I don't think I tendered a copy of the federal liberal law. So I gave it to the clerk, and I can see the blue tag on it. And, Your Honor, the federal civil lawsuit has been tagged, identified as Bryan Exhibit number 51? 51.
Any objection?
I'll tender that this time.
No, Your Honor.
No, you're on.
I think you'd rather I give this to the clerk?
Any one more from Greg McMichael?
No objection.
It's admitted. All right. I understand then. Mr. Goff, are you ready for your opening statements?
I believe we are, Your Honor.
All right. Let's go ahead and get the pen. And Mr. Goff, just to zero them in, I'm going to remind them that you had reserved your opening statement to the close of evidence.
Yes. Bailiff assist Ms. Berg. She needs a chair over there by the equipment.
All rise for jury, please. Please stand.
Oh, we're missing one.
All rise, please.
right, good morning, ladies and gentlemen. I know you're back here at 10 o'clock. Thank you for your patience. We're just addressing some matters before the court. We are ready to proceed with the case. With the state having rested, Mr. Goff had reserved his opening statement on behalf of Mr. Bryan. So the next portion of the case will be the presentation of opening statement on behalf of Mr. Bryan.
Thank you, Your Honor.
Are we good? One moment, Your Honor. Oh, okay. One moment, Your Honor.
Good morning.
I think it's still morning. Good morning, ladies and gentlemen. As you know, my name is Kevin Goff. I don't represent any McMichael defendants. I represent Roddy Bryan, this gentleman over here in the corner. And opening statement is an opportunity for you to give a preview, or in this case, overview, of what we expect the evidence to be in this case. I know it's getting close to lunch. I'm not going to try and go into every detail. That could take all day. But I would like to highlight for you what we believe is some of the important evidence for you in arriving at the truth here and in arriving at a just verdict for Roddy Bryan. I'm going to begin from Roddy Bryan's perspective. And during our case, in our case, Mr. Bryan has no obligation to present any case. But during the presentation of our case, we expect to publish this exhibit to you, which you may or may not remember from earlier in the trial, or a portion of it. Roddy Bryan, on February 23, 2020, is working on his porch, front porch, minding his own business. And you can see Mr. Bryan there. Somewhere in that video, I can't see it right now, but there's a hammer somewhere behind Mr. Bryan. Matter of fact, you can just go ahead and play the video. You can see Mr. Bryan is working on his front porch. There's certainly no evidence that he's communicating with anybody else. There's no evidence that he's listening to any police scanners. There's nothing to suggest that he's participating in anything other than what it looks like. Repairing the front porch to his house. I can't tell if he's reaching for his hammer at that point, but it's there behind him, between him and the door. Oh, that's his tape measure, I'm sorry. And at some point in this process, the evidence shows, and you can see how big the yard is, and it goes off to the side, and you can see a tree in his front yard that's providing a lot of shade at this point in time. Mr. Bryan catches out of the corner of his eye something that's different. And as he moves to get a better view, of course, he sees Mr. Arbery, and then he sees a truck catching up to Mr. Arbery. And there are words exchanged. Mr. Arbery, this is to me, this is important. The evidence does not show that Mr. Arbery has reached out to Mr. Bryan. You know, there's been a lot of talk about driveway decisions. There's been a lot of talk about assuming the worst in people. And at this time, we're going to pan to the still. And the still is going to be exhibit. During the defense case, we'll be publishing this picture, which is marked as States 139. Now, we're not going to get into a big discussion about what Mr. Bryan does or doesn't know right now. The point is that as Mr. Arbery is running up to and past Mr. Bryan's home, this is, with all due respect, it could be something out of a Norman Rockwell painting. There's nothing menacing here. There's nothing dangerous here. Now you have to add in, this is a picture taken on a different day by law enforcement, but you have to add in Mr. Bryan, as you just saw in the previous video, working on his front porch. In this picture, the garage door is open. You can't see, but you do see in the other evidence in the case, Mr. Bryan's pickup truck parked in the driveway facing out with lumber in the back of it. And Mr. Arbery is the one who's coming up the street. Mr. Bryan's listening to music and obviously oblivious to what's going on that morning. Mr. Bryan has the opportunity before Mr. Arbery has the opportunity before Mr. Bryan even understands what's going on to say and speak out, help, call 911. There's crazy people after me. That doesn't happen. What Mr. Bryan sees from his front porch is an encounter that's, I believe, caught on the other Night Owl video. As we do that, Mr. Bryan hasn't assumed, the evidence would suggest that Mr. Bryan hasn't assumed the worst about anyone. That Mr. Arbery, for whatever reason, has assumed the worst about Mr. Bryan. Because if he's in distress, if he, in fact, is feeling threatened, he has the opportunity to reach out to Mr. Bryan. The evidence would suggest, and you saw the drone thing yesterday, which for all its limitations, shows you it's a fairly big neighborhood. There's a lot of houses on this Sunday afternoon. There's no evidence that Mr. Arbery ever reached out to help, for help, either to Mr. Bryan or anyone else in that neighborhood. But from Mr. Bryan's perspective, when he sees Mr. Arbery come by and he sees this truck, and I believe the truck is visible in this video, he's responding to what he's seeing. And what he's seeing is someone who's not asking for assistance and not asking for help. Now, you know, there's been a lot of talk about folks in this case and their motivations. I'm looking at it from the perspective of Roddy Bryan. Roddy Bryan, the evidence shows, knows the people who run by his house because he sees them. 4 or 5 of them. But the evidence shows that he's never seen Mr. Arbery before. Now, to be fair, it's a big neighborhood. And intuitively, the evidence would suggest Mr. Bryan knows the difference between running to something and running from something. But in this case, there's really no mystery. But when Arbery passes Mr. Bryan's house, with all due respect, we know why. And I think that we can discern that from the evidence. Now, on the second Night Owl video, of course, you can see Mr. Arbery, stop there, or go back a second. Okay. Obviously, something's taking place on the street. And then, what is Mr. Bryan's response? Because it's been suggested that Mr. Bryan is something other than who he is. And partly that's based on the words that Mr. Bryan himself uses, because he's not always the most artful. But I would submit to you that the videos don't lie. It doesn't matter whether Mr. Bryan said he was walking on one day or running the next. We can see from the Night Owl video that Mr. Bryan, I think as the police officer has acknowledged, is walking into his garage. Walking into his house. He's not running. and he does that, he does so without a weapon. He's got a hammer on the front porch. He leaves the hammer behind. He walks into his house calmly, and he retrieves his keys. You know, actions oftentimes speak louder than words. And in this situation, the evidence shows that Mr. Bryan, in fact, had a rifle in his house on the day of the shooting. Mr. Bryan does not retrieve his rifle. He does not get his rifle. The evidence is that Mr. Bryan does not even possess a handgun, but he does possess a rifle. He leaves it. Nor does he go in the kitchen. He's not grabbing a butcher knife. He's not going in the garage. He's not picking up a machete. He walks out to his car with a cell phone and his keys. And that speaks volumes as to the intentions of Mr. Bryan on the day in question. Now, also, interestingly, and it's at the very end of the video, I think, I guess we'll just wait for Mr. Bryan to walk inside his house, and then he's going to come back out. And I think if you look at the timestamp, which we know timestamps aren't always accurate, but in this case, we have no reason to question it. It takes approximately 13 seconds for Mr. Bryan to leave the lower right-hand corner, go in the house, get his keys, and come back out. Stop right there. Okay. And get into his truck. Now, and I don't mean any disrespect to my client here, but it doesn't really matter whether Mr. Bryan says he's angled to the left, or he's angled to the right, or he's angled good, or he's angled not so good, or he's angled with more or less emphasis. We can kind of tell from this Night Owl video as to whether Mr. Bryan can accurately recall events, whether he can even do that on February 23rd. What do we know? When Mr. Bryan initially pulls up to the street, in fact, Mr. Bryan is angled to the right, away from Mr. Arbery. So any statement that's being put out there to suggest that he's angled to the left, well, that's just not what the video shows. Now, he does pull back. Go ahead, you can play the rest of it. He pulls back briefly. Well, okay, and that's the end of it. But as he pulls back, he's straight in his driveway. That's what the evidence, the hard evidence shows. So people trying to suggest things or read things just into Mr. Bryan's words, my suggestion to you is your duty as jurors is to honestly seek the truth, to look beyond the words to the actual meaning that's intended. Now, I want to talk about the physical evidence in this case, because there's been a lot of talk or a lot of evidence or a lot of speculation about Mr. Bryan driving around the neighborhood. The physical evidence suggests, I would submit to you, that Roddy Bryan isn't out there like Evel Knievel. There's no evidence, for example, that he's tearing up his neighbor's yards. How do we know that? First, where are the pictures of all the damage done by Mr. Bryan's truck as he's going in and out of people's yards? There is no such evidence. Second, there's no evidence, and there will be no evidence, that neighbors complained or reported destruction of their landscape by Mr. Bryan. And that kind of makes sense. Anyone who's landscaped a yard knows how expensive that can be. And whatever has happened on February 23rd, and Mr. Bryan's been candid, he doesn't know exactly what's happened that day. But whatever's happened that day, if he's trucking through people's yards, tearing up their plants and their lawns, that's going to create its own set of problems. Now, we have I can't see it on these, and that's okay, but we have a deep, sometimes watery drainage ditch running along Merchant Burford. You do see it in some of the other videos that you've seen in this trial. And you hear about Mr. Bryan overshooting the road. The evidence shows another time he used the word crept out. Crept out good. Kind of hard to figure what that means, but what does the physical evidence tell us? Where is the evidence that Mr. Bryan left the road? We know that he said that he still had he could back up good, he still had his back tires on the road. We know that he didn't back down, he didn't go down into that ditch. However active the tense or the wording that he's using, we know that he didn't. Because There's no physical evidence, for example, that there's dirt or grass or anything on the underside of Mr. Bryan's truck. And again, we're talking out here where there's a ditch going down, and he's supposedly trying to run over Mr. Arbery. I think that's what the state tried to suggest. Where's the evidence that he did that? Because somehow he's not running through the ditch, and there's nothing on the undercarriage of his car. Interestingly, I don't know that there's a single picture out there of the front of Mr. Bryan's vehicle. In an aggravated assault case where Mr. Bryan is supposedly trying to run somebody over with his truck, we have lots of evidence, lots of discussion about the side of Mr. Bryan's vehicle. I think there's one picture of the back of his truck and not a single picture of the front. Now, is there any evidence to suggest that Mr. Bryan's Chevy Silverado is different from all the rest? That he must have a Chevy Silverado, it must be built like for flight or something, because it's all smooth on the front. There must not be a grill or a bumper or other things, because the physical evidence is inconsistent with what is being presented to you in this case. Context is key here. Does the evidence show, what does the evidence show? How hard can it be? Where is the evidence of someone who is evading and eluding who cannot go off-road? Is there any reason, does the evidence suggest that Mr. Arbery could not have walked off of the road onto a neighbor's lawn, onto Mr. Bryan's front lawn, and cried out for help? Is there evidence that he couldn't have stood behind a tree or so much as a mailbox? Does the evidence suggest that Mr. Bryan ever did or was even prepared to leave the path of the road, to leave the road? Is there any evidence that anyone did that or was prepared to do it that day? And, you know, let's talk some more about physical evidence. There's no evidence from Roddy Bryan's truck's computer system. You've heard testimony about there. We may hear more about it. But you have heard Mr. Bryan's statements, and we'll play portions of them again before this case is over. Mr. Bryan cannot know, for example, as he speaks to Officer Minshew on the side of the road in the moments after the shooting, he can't know whether the computer chip in the truck has recorded the information. Obviously, that's something that motor vehicles do. That's why the police looked at it. He doesn't know that. He doesn't have time in the seconds before Officer Minshew arrives on the scene to go be manipulating or configuring his motor vehicle's computer chips or the data that's stored on it. Where is the evidence that he even attempted to do that? Now, we know that it took months for the police. The evidence is that it took months for the police to go and examine that chip. And by that point in time, the evidence has been lost. But there's no evidence that that's the result of deliberate acts on the part of Mr. Bryan. When Mr. Bryan is talking to Officer Minshew on the side of the road, he has no way of knowing what that evidence is going to show. Where is the physical evidence on the roadway, on Burford, on Holmes? Where is the physical evidence of Mr. Bryan driving aggressively? Where are the tire tracks, the brake marks, or the skid marks for all the times that Mr. Bryan has supposedly stopped short or changed direction without destroying any landscaping or mailboxes? Where is the evidence on the roadway itself of any aggressive driving? Now, there's been testimony. Mr. Bryan's never denied that he attempted to block the path of travel of Mr. Arbery. That's never been denied. You've heard Mr. Bryan acknowledge that on February 23rd on the side of the road, down at the police station, later with the GBI. But the manner in which that's done, where is the evidence that that's done in an aggressive manner? It's been suggested that Mr. Bryan tried to run over Ahmaud Arbery as he comes back in front of his driveway. Now, when we last see Mr. Bryan's truck in the Night Owl video, it's already at the end of the driveway, sticking somewhat out in the street far enough that he can see around the bushes that would otherwise obstruct his view. That looks like a two-lane road to me. I guess we could ask one of the witnesses about it, but generally these roads are about 10 feet across.
How is Mr. Bryan going to accelerate from a stop when he's already in that road? And he's going to jump out there and try and hit Mr. Arbery. But we know the physical evidence is inconsistent because Mr. Bryan has to stop his vehicle before he completely leaves the road. He has to stop his vehicle so he doesn't go down in that ditch and hit the front of his car to the far side of it and go through it and pull back up. Where is the physical evidence to suggest that Mr. Bryan did anything more than what he said, creep out of his driveway to try and cut off Mr. Arbery? The physical evidence is inconsistent with the kind of aggressive driving implied in this case. What about the lumber in the back of Mr. Bryan's truck? That's evidence in this case. It's kind of hard to see at the moment, but right around there you can see lumber in the back of the truck. Now, if you cross-reference that to the first Night Owl video, I'm not going to ask her to go back and play that again, but if you cross-reference it, those appear to be, if the ones in the truck match the ones on the porch, they're 2x8s. On the scene afterwards, have any of those been lost? Is there any evidence of a 2x8 going through the back of Mr. Bryan's windshield? Do we see that at the scene? Is there any evidence that Mr. Bryan had to drive back around the neighborhood, picking up various things that flew out of his truck during this aggressive maneuvering? There's no evidence of damage to the bedliner or to the tailgate. There's not even a scratch attributable to the supposed acrobatic maneuvers implied by the state. Did they attempt to fingerprint the lumber to see whether Mr. Arbery attempted to liberate a 2x8 from the back of his truck? Nobody is looking for this evidence, ladies and gentlemen. And the reason nobody's looking for it is because it's clear, the evidence is clear from the context of all Mr. Bryan's statements, that he never attempted to assault Mr. Arbery with his motor vehicle. The evidence shows that any attempt to describe Mr. Bryan as having engaged in that behavior would be shamelessly twisting words. No witness will testify that they saw Roddy Bryan driving aggressively or recklessly. No neighbors will testify to that because it didn't happen. We have no videos of aggressive driving. Certainly not Mr. Bryan's video, where he's moving at 2 miles to 3 miles an hour. We have a neighborhood chock full of security cameras, but there is not evidence from any of those cameras showing any aggressive driving on the part of Mr. Bryan. Take that down. Now, I can't presume what anyone else is going to do in this case or any other lawyer or lawyers, but based on the opening statements of Travis McMichael's counsel, I think the evidence is going to be that Travis McMichael will testify about the events of February 23rd. And a lot of that conversation probably doesn't involve Mr. Bryan. There's no evidence that Mr. Bryan was present on February 11th during previous encounters between Mr. Arbery and other defendants in this case. There's certainly no evidence that he's ever spoken to Larry English, although he's told the police he's on this Exit 29 Facebook page, which does apparently cover these matters. But we want you to focus, from Mr. Bryan's perspective, not on all this stuff going on down at 220 Satilla. We want you to focus on what Travis McMichael is going to tell you about Roddy Bryan. Based on the opening statement, we expect Travis McMichael will testify that he really didn't know Roddy, that Travis McMichael nor his father sought Roddy Bryan's help, nor that they communicated with him about the English situation or crime in the neighborhood or about anything else prior to the shooting on that day. I believe, if I recall Mr. Rubin's opening statement correctly, Travis McMichael is going to testify that he observed not Roddy Bryan attempting to run over Ahmaud Arbery. That would be a crime.
what Travis McMichael has observed, consistent with the statements made by Roddy Bryant at the scene, moments after the shooting, later that night, and subsequently with the GBI, consistent with those statements, that Travis McMichael saw Mr. Arbery acting aggressively, trying to get into the vehicle of Roddy Bryant. Now, that is an important consideration. It may be more important in one way for other defendants in this case. But in terms of Mr. Bryant, it helps inform why Mr. Bryant is engaging in the behavior that he does, to understand the context behind the words that Mr. Bryant has used in these interviews with law enforcement. The evidence is that when Mr. Arbery tried to get in his truck, at least the time that Mr. Bryant was aware of it, that scared Mr. Bryant. He pulled up fast, the fastest he's gone during this encounter, putting distance between himself and Mr. Arbery. Because it's dawned for the first time on Mr. Bryant that this situation is more fraught with peril than he might have realized standing on his front porch. That's important because when you see the video, it helps inform why he's doing the things he's doing. And when he says that he's keeping a distance from Mr. Arbery in everything that follows, it makes sense. And it will inform your judgment at the end of this case. Now, there is a key piece of evidence in this case, obviously the now famous video. And relax, I am not going to replay the video yet again. We did that just yesterday afternoon. I'm not going to do it again. But the evidence in that video is consistent with what, from the perspective of Roddy Bryant, is not conspiracy. It's chaos. We can look at these maps, we can look at these diagrams, these drones, for what they're worth. But the evidence shows that this so-called evidence is speculative in nature. And we know that. And it's mistaken in various respects. But we know from the video itself what Mr. Bryant is doing on that day. Now, we're going to play something else in a moment. But there's two things I want to remind you about the video. I'll try and move faster. Two things. First of all, the evidence shows that Mr. Bryant is not trying to run Mr. Arbery down. You can see him pacing him, following him at what the speedometer shows to be 2 to 3 miles an hour. Second, in the final moments before Mr. Arbery's tragic death, the evidence, the video, shows Mr. Bryant's efforts to track Mr. Arbery's movements prior to his tragic death, to keep him in view. And that focus is predominantly focused to the right, towards what would appear to be, from Mr. Bryant's view, the logical exit or escape path for Mr. Arbery out of the neighborhood, consistent with other evidence suggesting that Mr. Bryant was at that time attempting to take a video and record Mr. Arbery rather than shoot him or hurt him or be a party to that. There's scant evidence in this case that Mr. Bryant attempted to conceal or minimize his involvement in the events of February 23, 2020. There's no evidence that he sought to justify his actions on February 23, 2020. Probably because his actions on that date were not called into question by any of the police officers that spoke with him. Mr. Bryant, the evidence shows that Mr. Bryant didn't attempt to defend himself. He didn't try to justify himself. He was unaware that he had any reason to do so. Now, I want to talk briefly about what's probably the most important evidence from Mr. Bryant's perspective in this case, and that is the body cam of Officer Minshew, where Mr. Bryant is talking about this incident in the minutes afterwards. And he's given opportunities to minimize his involvement in the events of this day. And I'm not going to play it yet. We're only going to play one excerpt. We're not going to have 1,000 breaks in this. but you have heard the testimony that Officer Minshew gave Mr. Bryan an out, gave Mr. Bryan an obvious opportunity to minimize his involvement. So you're just a passerby. What does Mr. Roddy Bryan say? Oh yeah, let me go home. No, he says not exactly, because he doesn't know what he is. And he's honest enough with the police officer to convey that. Now, at another point, there's a question, should Roddy have been chasing him? The answer is, I don't know. We'll discuss some of these issues more in closing, but the evidence would again suggest that this is not somebody who's trying to minimize his conduct. Mr. Bryan says on February 23rd that he acted instinctively. The evidence shows that he was candid, that he can't articulate exactly why he did what he did, other than his general awareness of what was going on in the neighborhood, what had happened to him and his family, and what he sees that day. Now, there's been a lot of speculation about this video and about why it's being taken and how much video there is or videos there are. And I think the demeanor of Mr. Bryan is also evidence for this jury to consider. And we're going to play a brief portion of that. Okay. One moment, Your Honor. Well, looks like we won't be playing that excerpt from the video, but we do intend to play that. And Mr. Bryan didn't come up with this theory that he's trying to document what's going on when he spoke to Agent Sechrist. Officer Minshew speaks with him on the side of the road, and you're going to get to hear that because we're going to publish that to you during the presentation of our case. And Mr. Bryan is the one who tells the officer he's got it. He thinks he's got 2 or 3 videos. He doesn't know what he has because he hasn't had time to review it in the moments before the officer arrives on scene. And he invites the officer to sit in his car, not bragging, not boastful, not seeking attention, simply trying to help the police understand what's going on. And he tells you he doesn't even know what's there, but you get to see that in this case. And the police officer, Officer Minshew, is talking to him right there on the video, says, well, why'd you take it? Because I thought Mr. Arbery was going to get away and I wanted to document it for the police. That's not something that was created by lawyers months later. That's something Mr. Bryan says that day. Do we have the loud? Okay, well, we won't be playing that one either this afternoon. All right, and that's my fault. There's an excerpt from the interview of Mr. Bryan with Mr. Lowry that you will hear during the defense case in chief. It was suggested earlier that Mr. Bryan wished that he hit Mr. Arbery, suggesting that he wanted to hit Mr. Arbery or intended to hit Mr. Arbery. And while you can look at those words on a sheet of paper and you can see them, when you see Mr. Bryan in the interview room saying those words, the evidence will show that Mr. Arbery didn't have any intent to strike Mr. Arbery. That after the fact, sitting there with the police officer, looking back, hindsight's sometimes 20/20, that if he had hit Mr. Arbery and stopped him, that he might have saved his life. And when you see his demeanor and you put the words to it, the evidence will show that Mr. Bryan did not intend to harm Mr. Arbery, never intended to harm Mr. Arbery, that he regretted Mr. Arbery being injured. And looking back, he wished he had done more or done something better or different so that Mr. Arbery would not have been shot. And again, the context is the key. Now, I'm going to suggest to you that that clip and the other evidence suggests that Roddy Bryan legitimately struggles to find the right words in this case, that he struggles at times to convey the meaning, the truth behind those words. There is no evidence that Mr. Bryan is some kind of clever wordsmith, that his statements to the police that day are clever wordplay. There's no evidence that Mr. Bryan is playing word games with the law enforcement officers. He's legitimately struggling. And your job as jurors is to honestly seek the truth. Your job is not to play gotcha games with one party or another. And we think that the evidence shows, in context, Mr. Bryan had no intent to strike or injure Mr. Arbery. But if you look beyond his actual words, you'll see that. Now, the evidence is that Mr. Bryan, or will be that Mr. Bryan did not call 911. And maybe he should have. But we believe the evidence shows under the circumstances that he could reasonably assume that someone else did. Maybe he should have stayed on his front porch. It's been suggested that Mr. Bryan, acknowledging that his life would be so much easier if he had stayed on his front porch, that somehow that is a consciousness or acknowledgement of guilt. I think when you look at those words in context, you can see that they are anything but. The evidence will show that the key evidence in this case, the video that Mr. Bryan took on the day in question, that Mr. Bryan is the reason we have that evidence, because for whatever reason he turned around and went back. It was Mr. Bryan who produced not just the video, because if he was trying to minimize his involvement in this case, that cell phone could have wound up in the marsh long before anybody even realized it mattered. That didn't happen. The evidence is it's Mr. Bryan who alerts everyone to its presence. Even then, what's the second most important piece of evidence in this case after the video that Mr. Bryan makes? I would respectfully submit to you that it's the night owl video of the truck passing in front of his house with Mr. Arbery. Again, that's Mr. Bryan producing the evidence. Matter of fact, I think the evidence shows, or will show, that the police, the Glenn County Police Department, somehow in canvassing the neighborhood, missed his house, probably because he wasn't home. Nobody knew it was there. The evidence doesn't show Mr. Bryan attempting to delete anything from his cell phone. We've got all these forensic people from multiple police departments looking at this thing over and over. Likewise with the night owl video. It's Mr. Bryan who brings these police officers to his house where he lives, invites them in. And they can't get the video. But that's okay. No, you can come back later. I don't need my lawyer here. You can come back. Whatever you need, you can have it. It's Mr. Bryan that is responsible for that evidence being before you in this case. But that supposedly is evidence that Mr. Bryan is trying to conceal something or hide something or minimize his role in this case. And ultimately, you're going to have to decide what the truth is. You know, it wasn't some slick lawyer on the side of the road on February 23rd advising Mr. Bryan. You can see who's on the side of the road. It's in all these body cams. There's no slick lawyer counseling Mr. Bryan, unlike perhaps others. There's no evidence that Mr. Bryan has a lawyer. There's no evidence of him calling any lawyers. If he called anybody, you know about it because they've got his phone. It was Mr. Bryan on his own with his 12th grade, whatever it is, education, who's making the decisions out there for the truth to come out and for the truth to be known. And you hear it in his voice on that day on the side of the road. He doesn't know anything about the law. He just has a gut reaction to try and do the right thing. And you hear that. It's not, there's no complicated legal strategy. Mr. Bryan made the decision to cooperate with law enforcement in an instant on the side of the road that day. Never looked back and continued to cooperate with law enforcement all the way to today. It's Mr. Bryan who invites the police in his truck. Officer Minshew sits with him in his truck and looks at the evidence for the first time. He's inviting people to his house. He's given them his truck over and over again because he's trying to hide something. Now, on February 23rd, Roddy Bryan put his fate in the hands of the Glenn County Police Department. He put his trust in law enforcement officers that he did not even know. He put his trust in our government to do the right thing. That's what the evidence shows. And now he finds himself here before you, and he's placing his fate in your hands. And if the evidence is as we expect it to be, we're going to come back and ask you to return a verdict of not guilty.
All right, ladies and gentlemen, I know it's been a little bit of a disjointed morning with your movements. We're going to go ahead and break for lunch, though. We're going to break until 1:10 Enjoy your lunch, and we will see you at that time for the continuation of the case. Again, do not discuss this case amongst yourselves during the break. Thank you.
All right for the jury.
All right, we'll be in recess until 1:10. Thank you. Oh,
Can I bring up one quick matter?
yes. I should have gone around, but yes.
That's okay, usually you go around. Judge, I couldn't help but notice as I'm sitting in this chair, juror number 12. And I've watched her before nodding off during the presentation of evidence, noticed it in my opening statement, noticed it again in Mr. Bryan's opening statement. I don't know if she's got taking medication or doing, but she's eyes are closed, head is falling forward at times, and then she struggles to lift her eyelids. I would ask the court to keep an eye on her and ask me to let the jury stretch or stand up.
What I will do is I hadn't noticed that. I will go ahead and, you said 12? 12.
And
I'll keep an eye on 12. I'm going to ask the courtroom deputies just to keep an eye on her too, and we'll see what's going on. And I will I'll make a comment not directed at her, but generally to the panel, that they need to make sure that they are paying close attention to the evidence, and if anybody is struggling with that, to help their neighbors and ensure that we can keep their full attention.
thank you.
All right, thank you. All right, I should have done it. Anything to mistake before we recess?
No, Judge.
I assume that was it from Mr. Travis McMichael?
That was it.
And Greg McMichael?
Nothing.
From Mr. Bryan?
No, Your Honor.
All right, we'll see you at 1:10. Thank you.